Good morning and welcome to the 294th District Court. My name is Chris Martin. I'm going to call this morning's criminal docket. When you hear your name, please say present or here. Jesse Lowry. Here. Sean Allen. Here. Dorothy Harvey. Dorothy Louise Harvey. Michael Patterson. Jenna Prox. Gina, is it Jenna or Gina? Gina. Clayton Spencer. Clayton James Spencer. Justin Yeager. Mario Martinez. Or Mario Martinez, I'm sorry. Alyssa Rodriguez. Michael Tuff. Maria Flores. All right, good morning. And I do have my court interpreter, so we'll take your matter up first. LaRonda Alexander. Catwalla Anderson. Gilberto Jimenez. Maria Malicio. Delvin Mitchell.
Your Honor, my office has been in contact with him. He's on his way. He should be. Right.
Justin Williams. All right, Ms. Turner, are you ready on this Flores?
Yes.
Go ahead and bring her up. Good morning, Ms. Beal.
Good morning, Judge. How are you?
Yes. You have to unmute. You have to unmute that laptop.
I'll say Holly.
She's here. And I'm on the English channel. Did you switch that one over to Spanish?
Yes, sir. Says my network with bandwidth is low.
What Wi-Fi network are you hooked up to?
I'm on the VZDJ.
No, it's connectivity.
I'm not getting bandwidth.
Is it? Are you on VZDJ or are you on Van Zandt Public?
I'm on VZDJ.
Where's that?
Our bandwidth is low. Disconnected. Want me to go to Buffalo?
Buffalo is preferable always.
Says we're connected to Buffalo.
And I think Holly was having some issues also, so she logged out to log back in.
Okay. Okay, now we see Holly.
Yes, ma'am. Yeah, I've got you. But you have to unmute that. Just click that button.
No, it says it's failed to detect our microphone.
Unplug the headphones and plug them back in.
Morning.
Okay, I hear. You hear?
No, so Holly's not gonna be able to. Well, test it, Holly, and see if.
Holly, can you hear us now?
All right, before I call the case, I'm gonna swear you in, Holly. You'll raise your right hand and state your name and your license number for the record. Ms. Bill, do you solemnly swear or affirm that you will make a true translation of the statements of the court, the questions of counsel, and the testimony to be given in the matter on trial to the best of your skill and judgment? So help you God. All right, thank you. All right, this is cause number CR 24-305, State of Texas versus Maria de Perez Flores. We are set for pretrial today. Any announcements, Ms. Turner, on pretrial?
Your Honor, I spoke with the state earlier. I'm waiting to get access to the discovery portal, so I don't have any discovery yet. I do have an offer now, and I would just ask for another setting for me to receive discovery.
Is there a reason we're only getting discovery today? It's pretrial, we've already been arraigned, we've already had a reset. Is there a reason that you don't have discovery in the case?
No, sir, I wasn't aware that I had to get access first from the portal and then get the discovery.
And Your Honor, I think that's a little bit of cross communication. We had Mr. Schmidt still as the attorney in our file. I do see that Ms. Turner filed a letter now. So I think it's a little bit of ships crossing in the night, but we are working to correct that situation now.
All right, court's gonna reset pretrial. Do you know how long you need, Ms. Turner?
About 30 days, Judge. It's fine.
Can we do a little bit less than that? Can we do April 15th or 17th? It's about 3 weeks.
Yes, Your Honor, April 17th is fine.
17th?
Yes, sir.
All right, court sets Ms. Flores for pretrial on April 17th. We'll set that at 9:15. And we'll make arrangements for her to have an interpreter available that day as well.
Thank you, Judge. Oh, excuse Your Honor.
Yeah, once she signs her notice of setting and gets the yellow copy, she's free to go. All right, thank you, Holly, so much. I don't know what that issue was, but sometimes their little gremlins get in there, so. Thank you. Have a great day. right, do we have any other counsel or cases that are ready? No? Nobody's ready to go? Is Dorothy Harvey here? What about Clayton Spencer? Is Clayton Spencer here? Clancy, are you ready?
I am ready and prepared for motion. Alfredo talked to me this morning because I not received a plea offer prior to today. Even though we've had multiple attempts trying to request a plea offer. He just conveyed one to me. My client's discussing it.
Okay.
I need to go over the details with them real quickly to see what we're looking at.
Okay, it's
If we can just have five minutes, Judge.
fine. Are you ready on?
Mike's tough.
Michael Cole Tuff, CR 22-296. Mr. Tuff is on a motion to adjudicate. Go ahead.
That's correct, Judge. I've been meeting with the state. We've got some out of county information we're trying to track down. I asked for another reset on Mr. Todd.
Any objections from the state?
No, Your Honor, Mr. Schmidt has been in communication with me about that.
All right, court will set this for a final hearing on April 29th.
Listen, Rodriguez.
Alyssa Michelle Rodriguez, CR 18-175. Motion to adjudicate. Go ahead.
Judge, we've reached a resolution with the state. Ms. Rodriguez got a few things she needs to take care of beforehand, but we'd like to set her for a plea. I guess we could do it on the same day. Like April 29th.
29th. All right, court sets Ms. Rodriguez for plea before the court, April 29th. Is that a morning or afternoon plea?
Morning, sir.
Who do you want next?
Mario Martinez.
Mario Martinez, CR 21-178. Mr. Martinez is also on a motion to adjudicate.
That's correct, Judge. Similar amount. Got an offer from the state, but we've got some other issues that we're trying to work through. It asked for an additional setting.
No objection, Your Honor.
All right, court will set Mr. Martinez for a final hearing on April 29th. Is that all you have this morning, Mr. Schmidt?
For now, Judge.
Approach.
Mr. Lowry, come forward. This is cause number CR 24-171, State of Texas versus Jesse Lowry. You may approach. Thank you. CR 24-162, State of Texas versus LaRonda Shante Alexander. Ms. Alexander, if you'll raise your right hand, I'm going to place you under oath. Ma'am, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So I can't.
Yeah.
Thank you, Mr. Lawyer. Just gotta make sure you speak up so I can hear you and so my court reporter can take down what you have to say, okay? All right, Ms. Alexander, your name is LaRonda Shante Alexander, is that correct?
Yes,
And Ms. Alexander, are you a United States citizen who reads, writes, and speaks English?
yes,
Have you ever been diagnosed with a mental condition?
no,
In this case, you're represented by your attorney, Mr. Nolan White. Are you pleased with Mr. White and the work he's done as your attorney?
yes,
Do you have any questions about your plea agreement or anything else?
no,
Mr. White, do you believe Ms. Alexander to be competent today? And if so, have you explained to her her rights regarding this case, including the advantages and disadvantages of her adjudication plea?
Your Honor, I believe Ms. Alexander is competent, that she understands the proceedings that are pending against her here today. I believe that she's waived her rights knowingly, intelligently, voluntarily. I've explained the advantages and disadvantages of entering into such a plea. In that, if she violates any term or condition, the court can hold a hearing, and if the court so finds by preponderance of the evidence that she did in fact violate her probation, then the court would have the entire range of punishment as disposal, which is up, in this case, 20 years in the Texas Department of Criminal Justice and a fine not to exceed $10,000.
Thank you, Mr. White. Ms. Alexander, you are charged by indictment with a second-degree felony offense of possession of marijuana greater than 50 pounds, less than 2,000 pounds. And that does carry a range of punishment of not less than 2 years in prison, up to a maximum 20 years in prison, and a possible fine not to exceed $10,000 should you be convicted and sentenced. I see that the plea agreement in your case is that you would be pleading guilty to this crime in exchange for the DA's recommendation that a finding of guilt be deferred. That means that the court would consider the evidence but not convict you today. And the court would place you on 4 years community supervision, also assessing a $1,500 fine, restitution in the amount of $180, court costs in the amount of $290, and reimbursement fees in the amount of $35. Ms. Alexander, is that your understanding of the plea?
yes,
All right, Ms. Alexander, how do you plead to possession of marijuana greater than 50 pounds, less than 2,000 pounds?
yes,
Are you pleading guilty to that crime because you are in fact guilty of committing that crime? And has anybody threatened, forced, or pressured you to plead guilty? Court accepts the defendant's plea of guilt at this time. Mr. White, any objection to the evidence supporting the plea?
No objection.
The evidence is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
Nothing further, Your Honor. Thank you.
Anything further from the defense?
No, sir.
Our court's going to review the evidence. All right, the court, having reviewed the evidence, does find enough evidence to convict the defendant of this offense. The court will, the state follow the plea agreement. Court hereby defers a finding of guilt on the second-degree felony offense of possession of marijuana greater than 50 pounds, less than 2,000 pounds. Court places Ms. Alexander on 4 years community supervision. Orders her to pay a $1,500 fine, court costs of $290, reimbursement fees of $35, and restitution of $180. Ms. Alexander, you hereby remanded to the custody of the probation department so they can carry out the terms and conditions of the sentence. I'm going to have you come forward to be fingerprinted with the bailiff. After that, you'll meet with the probation officers and they'll tell you about what's next. Okay. Mr. White, you ready on anyone else?
I believe did the court get my, on Mr. Mitchell?
I do not have any, you talking about plea papers?
Yes, sir. Let me, I'm sorry. I used to do it.
Not yet. Mitchell going to be a probation plea, so we'll need to alert probation to, you will go let them know they're gonna have to sign before it comes to me. So they may not be with. Mr. Clancy, are you ready?
Yes, we're ready, Your Honor.
Come on up. Mr. Lowry, come on. All right, and Mr. Clancy, do you have the waiver of jury trial form?
I do. Can I approach, Your Honor?
Yes, please. We are on record, call number CR 24-171, State of Texas versus Jesse Lee Lowry. Mr. Lowry, sir, if you'll raise your right hand, I want to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Lord, your name is Jesse Lee Lowry, is that correct?
Yes, sir.
All right, and before we go any further, Mr. Clancy, you had filed a motion to quash the indictment this morning, which the court set for evidentiary hearing. Any announcements on that?
Yes, Your Honor. Based on a agreed plea agreement with the state, we're going to withdraw that motion and move forward with a plea agreement at a future date.
All right, that is noted for the record. All right, Mr. Lowry, I have a document in my hand that's entitled Waiver of Jury Trial. And this tells me that you've spoken with your attorney, Mr. Clancy, about what it means to waive your right to a jury trial. Is that correct?
Yes, sir.
And it's important that I tell you that once you waive your right to a jury trial, that right may not be restored to you at a later date. Do you understand that?
Yes, sir.
And you understand that by waiving your right to a jury trial, Mr. Lowry, you're giving up other important rights such as the right to confront the state's witnesses and cross-examine them and the evidence that they offer before a jury of your peers. Do you understand that?
Yes, sir.
You will also still have the right to have a trial before the court, but you will be giving up your right to a trial before a jury. You understand that?
Yes, sir.
And Mr. Lowry, it's my understanding that you are waiving your right to a jury trial in order to move forward with accepting the state of Texas's offer to resolve your case by plea agreement. Is that correct?
Yes, sir.
It appears that the offer at this time being extended is 3 years deferred probation, 3 years deferred adjudication probation, and a $3,000 fine on this charge of theft of cattle.
Yes, sir.
And Mr. Lowry, has anybody threatened you, forced you, or pressured you to waive your right for all here today?
No, sir.
And you understand, as I said before, if you go home and you start thinking about this, and in a week or 2 weeks, or maybe 6 months in your probationary period, you decide that you didn't want to do that, you're not going to have the right to come back and tell the court, you know what, I want my trial before my jury. You understand that?
Yes, sir.
Mr. Clancy, you've explained to your client his rights as it regards to waiving the jury trial.
I have, Your Honor. I've reviewed the document with him as well.
And do you believe that he understands his rights and that he's waiving the same intentionally, knowingly, and voluntarily?
Yes, I do, Your Honor.
Court will find that the defendant, having been admonished of his right to a jury trial, has waived the same intentionally, knowingly, voluntarily, has had the assistance of counsel who is also signed with the defendant. Court also finds that the criminal district attorney has also waived the state's right to a trial before a jury in this matter. Court hereby approves the waiver of jury trial. All right, when would y'all like to come back to do the plea? Is there any?
I'm open to the court's docket. If I just check my calendar, if you have a couple days in mind, Your Honor.
Is there a necessary time to get money or anything for the plea?
Well, financially, he's not going to be able to pay up front on the fine. He'll need a payment plan. I don't think there's any other restitution involved in this case. Restitution's been paid up front.
I have some dates available here in a few weeks. If you want to do that, we've got April 10th. It's a Thursday, and then the following Tuesday and Thursday. So the 10th, 15th, or 17th.
I can do the 17th. Can you do the 17th, Mr. Lowry? 17th works for us, Your Honor.
17th. Okay. All right. Report hereby sets Mr. Lowry to enter his plea before the court April 17th at 9 a.m.
Thank you, Judge.
You're welcome.
May we be excused, Your Honor?
Ready to go.
Okay, thank you, Judge.
You're welcome.
Yeah, leave it there. You see the yellow. Okay. Okay. Yeah, call. Yeah, thank you. All right. No problem. Anytime.
Good to see you, Mr. President.
Good to see you too, Your Honor. Have a good day.
You as well. Mr. Manning, you ready?
Ready on Mr. Patterson?
Mr. Patterson, if you'll come forward, this is cause number CR 23-15, State of Texas versus Michael Scott Patterson. I believe we're set for arraignment today. Is that correct, Mr. Manning?
Yes, Judge. I've had an opportunity to go over the indictment with my client. He understands the charge against him as well as the enhanced range of punishment. His plea is not guilty, but requests to be set on pretrial docket.
All right, court finds that Mr. Patterson, having waived the formal requirements of arraignment, enters his plea of not guilty into the record. Court sets this matter for pretrial hearing Thursday, May 1st, Mr. Manning.
Yes, Judge.
Once Mr. Patterson signs, gets his notice, he's free to go.
Additionally, Judge, I have requested discovery today, and I believe we should be getting that by the end of the day.
All right, thank you, Mr. Manning. Who would you like next?
Judge, next, if you want to take up Mr. Spencer.
Clayton James Spencer, CR 25-25. We're set for pretrial today. Mr. Spencer still not here.
No, Judge, I was able to speak to Mr. Spencer on the phone. It seems there was some confusion based off of his release from jail last time. And our conversations, as well as his conversations with his bondsman. He stated that he is out of town and unable to be here today. However, he did state that he could be here and sign reset tomorrow if the court would permit that. I explained to him that he did, back when he was in custody, sign the reset for today at 1:30, and that he not received any information otherwise from me or from his bondsman to tell him that he was.
Do you have any announcements on pretrial?
Well, Judge, I had filed a motion to suppress on this case, and so I would ask that we postpone that until Mr. Spencer can be present.
Any requests from the state?
Your Honor, as far as the motion to suppress goes, state agrees that that should be kind of carried forward until Mr. Spencer can be here and Mr. Manning can address that with him present. As far as Mr. Spencer's failure to appear today, state can certainly understand that reminders are helpful but he did sign a reset. State would request that he be given till the end of the business day to turn himself in or to appear. But wouldn't would understand if the court granted defense's request that he appear tomorrow as well.
All right, Mr. Manning, court will, we're going to continue your evidentiary hearing to April 29th. So 9 o'clock. Have Mr. Clayton's name called loudly, distinctly at the end of the docket. And I'm not going to extend to him the opportunity to be here tomorrow. So the court, if he's not here by the end of the docket, the court's going to issue a judgment not citing alias capias. Once Mr. Spencer's back in custody, then the court would entertain a motion to reinstate bail.
Yes, Judge. And I will see if I can reach out and communicate that to him. Like I said, he was working a job, and I will see if that may motivate him to try to weigh cost benefit there.
Please do so. And, if that's an issue, then if he'll just notify you and let you know, you could always request that he appear via Zoom, and that might be granted as it's granted to many other people. But I understand working. I understand that they need to be there, but I need to know what's going on with him.
Yes, Judge. And that dovetails, Judge, into Mr. Yeager. Mr. Yeager was set on Tuesday. And that case was carried over due to my vacation letter.
Is Mr. Yeager here?
He's not a judge.
Yeah, he's here. Yeah, I checked him off. Yeah, come on up, Mr. Yeager. Come on. Yeah, maybe he's here because I called roll earlier, but I think you were out working another client.
Thank you, Judge.
All right, this is cause number CR 24-308, State of Texas versus Justin Tanner Yeager for pretrial.
Yes, Judge, at this time, we have no contested pretrial. We request to be set on the docket call. So,
All right, court sets Mr. Yeager for docket call on Thursday, May 1st. And once he signs and gets his notice, he's free to go.
Judge, and I just want you to know that Mr. Yeager overcame extraordinary obstacles to be here today. When we last talked yesterday, it was going to be very difficult. So I was glad to see him.
Thank you, Mr. Yeager. Appreciate you being here.
Just Judge, next ready on Ms. Crocs.
Gina Lynn Prox, CR 24220. Also CR 24221. Prox is set for pretrial today.
Judge, for me, so. Your Honor, may I report?
Yes. Yeah, anyone else this time?
Judge, I have one, sorry, I have two more, and I see. The one that I am ready on is Mr. Sean Allen.
John? This is cause number CR 24-253, State of Texas versus Sean Michael Allen. Dr. Paul.
Yes, Judge, we have been in negotiations with the state and, they requested today some prerequisites to be met before they would consider our counter offer. My client was able to meet those prerequisites, and so we would ask for a reset for the state to consider our counter offer for resolution of this case.
Objection, Steve.
No objection, Your Honor. Thank you.
All right. How much time do you need?
What are the next coming up dates, Your Honor? I'm sorry. I guess. Your Honor, I think by the 15th should be good.
So let's do 17. He comes on.
Oh.
Thank you, Judge.
All right, court sets, Mr. Allen then. Dr. Paul, April 17th.
And like I said, Judge, I believe that that day will be dispositive of this case. Judge, that's all that I have ready right now. Can I be excused?
Yes, sir. Mr. White. Yeah, have potential plea papers. Mitchell. This is cause numbers CR 24-103, State of Texas versus Delvin DeMarco Mitchell. Mr. Mitchell, sir, if you'll raise your right hand, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, you can lower your hand. All right, Mr. White, you had filed a motion to suppress in Mr. Mitchell's case. Is that correct?
That's correct, Your Honor.
Is it my understanding that the defendant is wishing to withdraw that motion to suppress and resolve his case by plea agreement today?
That's correct, Your Honor.
All right. All right, Mr. Mitchell, are you a United States citizen who reads, writes, and speaks English?
Yes, sir.
Have you ever been diagnosed with a mental condition?
No, sir.
In this case, you're represented by your attorney, Mr. Nolan White. Are you pleased with Mr. White and the work that he's done as your attorney?
Yes, sir.
Do you have any questions about your plea agreement or anything else?
No, sir.
Mr. White, do you believe Mr. Mitchell to be competent? And if so, have you explained to him his rights regarding this case, the advantages and disadvantages of the deferred adjudication, and whether or not he's entering into this agreement intentionally, knowingly, and voluntarily?
Your Honor, I believe Mr. Mitchell is competent, that he understands the proceedings pending against him here today. He's waived his rights knowingly, intelligently, voluntarily, and I've explained to him the advantages and disadvantages of the deferred adjudication. Well, most notably, if he violates any term or condition, the court will hold a hearing. If the court so finds by a preponderance of the evidence that he did in fact violate his community supervision, the court will have the entire range of punishment, which is up to 10 years and $10,000 fine. Okay.
Thank you, Mr. White. Mr. Mitchell, you are charged by indictment with possession of marijuana greater than 5 pounds, less than 50 pounds. That is a third-degree felony. As Mr. White has stated, it does have a range of punishment from a minimum 2 years in prison up to a maximum 10 years in prison, and a fine, if imposed, not to exceed $10,000. That's the potential range of punishment should you be convicted and sentenced on this crime. I see that the plea agreement in the case is upon your plea of guilt. The DA's office is recommending that the court consider the evidence but not convict you, rather to place you on deferred community supervision for a period of 4 years. Also, a $2,000 fine plus court costs of $290, reimbursement fees of $105, and restitution of $180. Mr. Mitchell, is that your understanding of the plea agreement?
Yes, sir.
All right, Mr. Mitchell, then understanding all of those things, how do you plead to the third-degree felony possession of marijuana greater than 5 pounds, less than 50 pounds?
Guilty.
And Mr. Mitchell, are you pleading guilty to that crime because you are in fact guilty of committing that crime?
Yes, sir.
Mr. Mitchell, has anybody threatened you, forced you, or pressured you to plead guilty here in court?
No, sir.
All right, the court does accept the defendant's plea of guilt at this time. Mr. White, any objection to the stipulation of evidence?
No objection.
Stipulation of evidence is admitted. The court does take judicial notice of the defendant's judicial confessions. Anything further from the state?
No, Your Honor, thank you.
Anything further from the defense?
No, sir.
All right, court will review the evidence. All right, the court, having reviewed the evidence, finds enough evidence to convict the defendant. The court will follow the plea agreement today. Court places Mr. Delvin Marco Mitchell on deferred community supervision for a period of 4 years. Orders him to pay a $2,000 fine, court cost of $290, reimbursement fees of $105, and restitution of $180. Mr. Mitchell, you hereby remanded to the custody of the probation department so they can carry out the terms and conditions of the sentence. I'm going to have you come forward and be fingerprinted with the bailiff. After that, the probation officers will tell you more.
Yes, sir.
Your Honor, may I have yours?
Yes, sir. CR 23-197, State of Texas versus Catwalla Chantel Anderson. We're here today on a motion to adjudicate. All right, it's my understanding that there's an agreement between the state and the defense wherein the state's agreeing to withdraw their motion to adjudicate to continue Ms. Anderson on community supervision with a sanction of 3 days in the county jail to be served for technical violations contained in the motion, with Ms. Anderson being given the opportunity to pick the 3 days that she will serve. Is that your understanding, Mr. White?
Yes, sir. It is.
That's your understanding, Ms. Anderson?
Yes,
All right, Ms. Anderson, if you'll raise your right hand, I'm going to place you under oath. Do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So help you God.
I know.
All right, Galarian. All right, Ms. Anderson, you've made this agreement with the state today. Has anybody threatened you, forced you, or pressured you to make this agreement?
No,
Court will approve the withdrawal of the state's motion to adjudicate. The court hereby grants that. Court continues Ms. Anderson on community supervision, orders her to serve 3 days confinement in the Van Zandt County Jail, with those days to be picked by the defendant in consultation with the probation department. All right, Ms. Anderson, come over here and meet with the probation department, pick your days, and then you're free to go.
Yeah, very quickly, Your Honor.
Yes.
There was an underlying offense as part of this motion to adjudicate. My understanding from talking with Mr. Hartwell and Ms. Curry is the state will reject that. I know that's not part of this written agreement. That's all I understand.
That's correct, Your Honor.
Right, that's on the record. Dwight, you ready on anyone else?
That depends on Mr. Hartwell. Are you ready on Mr. Jimenez?
Yes.
Mr. Jimenez, you'll come forward. This is cause number CR 24-210 and CR 24-211. Show that we're set for evidentiary hearings today. Go ahead, Mr. White.
So, Your Honor, I filed a motion to suppress. I also filed a motion for discovery regarding some additional materials. Mr. Hartwell has indicated to me that the state is in the process of getting those additional materials. As part of my motion to suppress, I gave Mr. Hartwell a case. I think the court may have been given a copy of that as well. Mr. Hartwell and I agree that the factual matters in this particular matter are extremely similar to that case. My understanding is that that case is currently on PDR. I feel like that depending on what the court, obviously if the Court of Appeals upholds the ruling, I'm sure we may have to have another discussion, but I think that that could hamper the state's case quite a bit, if not be fatal to it. But depending on how the court rules and what the reasoning is, will certainly affect how I go forward on a motion to suppress. So at this time, I mean, maybe not in a classic sense, but I don't feel that this is right for the court to look at. I think that there's a high likelihood, depending on whatever the court's ruling is, that we could find ourselves back in here having to relitigate it. So I think the state joins, and if the court had given us some options, we're going to ask the court to reset on this. And that'll also give the state time to get the information on the drug dog that I requested.
Your Honor, state's in agreement. I think especially given the many ways the Court of Criminal Appeals could come down on this case could very well either be dispositive or at least inform us as to what facts we need to bring for the court to consider. So I think the best course of action is to carry the motion to suppress for the time being.
Okay. I'm gonna have him coming back every 30 days. Don't know how long it's gonna take the Court of Criminal Appeals.
We understand.
All right. Court's gonna reset Mr. Jimenez then for April 29th. We'll just do status of the ruling from the CCA.
This court, I mean, it's
Yes, free to go. You have anyone else, Mr. White?
yes, sir, Mr. Williams.
Justin Wayne Williams. This is CR 20-276.
We were set for an motion to adjudicate today. It was contested. State and I have come to an agreement on this, Your Honor. Now, there's an underlying offense out of Wood County on this. Mr. Williams has an attorney over there. I want to make sure it's not going to affect what we do from the standpoint of whether or not we accept the agreement or not. But I want to talk with him to make sure that we're coordinated because, as the court's aware, if he doesn't get probation, he's going to be subject to that DWI superfine. And I wanted to talk with Mr. Wilson a little bit about that because that's a significant amount of money. If we can set it for April 29th out at the jail, we'll be ready to go on that day.
And you expect this to be a plea or?
Yes, sir. It's going to be a plea for time. Yes.
Okay. All right. Any objections from the state?
No objection, Your Honor. Thank you.
All right, court will set this for plea on the motion, April 29th. You said it's a time, please, so set it at 1:30.
Yes, sir.
All right, so Mr. Williams, when you come back, it'll be at 1:30 in the afternoon out at the Justice Center. Okay, thank you. Roy, are you ready on Melissio? We already do Melissio.
Your Honor, I'm just checking to see if probation officer's here for that one.
Okay. All right, we are on record in cause numbers CR 24-220 and CR 24-221. State of Texas versus Gina Lynn Cox. All right, Ms. Cox, I find that you were negative on your UA test. That's good. I think Mr. Manning has brought to your attention that you're delinquent on your fines, not your fines, but on your pretrial release fees.
I have the money to pay it. I've been having issues online, so I was gonna do it before court, but I don't wanna be late, so I'm going as soon as I leave here.
Okay, how much are you gonna pay today?
The whole 200.
Whole 200, okay. All right, and Mr. Manning, how much more time do you need with the state on pretrial?
Judge, as we announced at the bench, if we could have a little bit longer on this one, just see how things unfold.
About June 12th?
Judge, I believe that, let me check. Judge, that it will work.
June 12th, all right, court sets Ms. Prox for pretrial June 12th in both cases.
Judge, pending that payment, may she be released?
Yes, and Ms. Prox, remember, you need to stay in contact with the pretrial release officer. Oh, yeah, but I'm just saying, I won't see you again until June because they've asked me to reset it. But in between, you need to be in contact with them. If they say drive in to meet with them and UA and do those things, you gotta get that done, okay?
Yeah, yes, sir.
All right. Ready to go.
Judge, last I'm ready on Ms. Harvey.
Ms. Harvey? Ms. Harvey here. Ms. Harvey, come on up. All right, this is cause number CR 24-231, State of Texas versus Dorothy Harvey for docket call. Go ahead.
Judge, Ms. Harvey was given an offer, which at this time she's rejecting and requesting me set on the jury selection docket.
What is the offer that was extended and rejected?
Judge, it was for probation on a Class A misdemeanor, but due to Ms. Harvey's homelessness, she does not feel like she's a good candidate for probation.
Okay.
Judge, I may be able to speak to the court. Speak to the state, and we find a resolution. But at this time, that's been the only offer, and this is Ms. Harvey's first time telling me that she's rejecting that.
All right, and your client understands that the court may not allow her to plead after today?
Yes, Judge, I explained that to her.
All right, Ms. Harvey, court will place you on the jury selection docket. We'll start that on Monday, March 31st. So when you report, you'll report downstairs. Ms. Abraham or another member of my staff will be down there. You won't report to the courthouse. You won't go to trial on that date, but you'll start on the trial selection process, which means that you'll continue to come until your case is set for trial or in the top 10. Mr. Manning may or may not be here. He's not going to be required to be here to meet with you on that date because you're not going to go to trial, but you do have to check in and get your reset date and check in with pretrial release while you're here, okay? All right. All right, we'll see you back on March 31st. At 1 o'clock. Tell you what, at 1 o'clock, Mr. Manning, make sure
Oh, yes.
we had to adjust that day, so put her to check in and something.
Sleep later.
Judge, I believe that concludes my business.
Yes, sir. We'll see you this afternoon. All right, Mr. White, ready? Ms. Malicio? All right, this is cause number CR 15-152, State of Texas versus Maria Edith Malicio. And I show that we're set for a hearing on the motion to adjudicate today. Mr. White, I found in the filing system, you filed a motion to quash yesterday. Is that correct?
That's correct, Your Honor.
Are you wanting to take that up today?
Yes, sir.
State, any objection to late notice?
Your Honor, I would, but I would ask, I know the court set this as a final deadline. I would ask for, rather than denying defense the ability to, present a full defense, a continuance so that state has an opportunity to fully address, the issues. And if there are, inadequacies in the motion, be able to correct those.
Mr. White, any reason the motion was filed late and not filed?
Your Honor, my understanding of the law is I just have to have this on file prior to the hearing commencing, which it is. Because, Your Honor, and I think the rationale is on that is if you point out the deficiencies in the motion, then the state goes ahead, and particularly in this situation, state's going to go ahead and amend. And it's been on file for quite some time and that's to deter that sort of behavior.
So you object to the request for continuance? All right, then we'll go forward.
Yes, sir.
All right, state, it's your motion. Would you like to call your first witness or make any kind of opening statement?
Your Honor, would we go ahead then and address the motion to quash first?
No, we'll go ahead with our evidence. He'll have to make his argument when it's time to, when the burden shifts, or the burden doesn't shift, but when he gets the opportunity to present a defense.
Yes, sir. Then state would.
Not allowed to make but the court's just going to hold its ruling on my motion to quash, but it's still going to entertain it.
Right. I'm going to go ahead and take the evidence, and then when we get to you, then I'll give you a chance to make the argument.
Okay.
Yes, sir. In Your Honor, state would call Jarvis Crawford, Van Zandt County Probation Department.
Robert, come forward. All right, Robert, you'll raise your right hand. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, everything, nothing but the truth, so help you God? Yes, sir. Just have a seat. Move that chair around. We'll adjust the microphone. During your testimony, just speak up loudly and clearly, and allow the attorneys to fully finish their question before you give an answer, okay?
Yes, sir.
And if either attorney objects to your testimony, just stop testifying.
Yes, sir.
Charlie,
Your Honor, would the court like me to present the motion to adjudicate to the defense so that they have an opportunity to plead true or not true to each count?
yes, we'll do that. Mr. White, does your client waive the formal reading of the motion, or would you like the state to present that?
Your Honor, at this time, Ms. Malicio will waive formal reading of the state's motion. We indicate court that we were going to enter a plea of not true to each and every count.
Okay, that's noted for the record. Thank
Thank
you.
you. And Your Honor, state asks the court to take judicial notice of the court's record and the clerk's file in this case.
Court takes judicial notice of all filings and cause number CR 15152.
Thank you, Your Honor. Good morning, Officer Crawford. Can you please introduce yourself to the court and spell your last name for the record?
My name is Jarvis Crawford, CRAWFORD, a probation officer for Van Zandt County Probation.
Thank you, sir. And how long have you been a probation officer with Van Zandt County?
It will be 12 years in June.
What are your duties as a probation officer?
Supervise people that have agreed to the terms of probation coming from the courts and make sure they're acting accordingly in lines with the conditions of probation.
And has your role changed or shifted over the 12 years that you've been a probation officer?
Slightly. I've moved over to mental health caseload, but the overall role is generally the same.
And Mr. Crawford, as part of your duty supervising probationers, did you supervise Miss Maria Malicio?
I did.
Do you recognize her?
I do.
Can you please describe an item of clothing and where she is seated in the courtroom today?
Black sweater and seated next to defendant's attorney, Mr. White.
Your Honor, may the record reflect that this witness has identified the defendant, Ms. Malicio?
Any objection?
Objection.
All right, then the record will reflect that this witness has identified the defendant in this case, Ms. Maria Edith Malicio.
And Mr. Crawford, do you know, do you recall offhand when Ms. Malicio came to your caseload?
Yeah, it's August 24th of 2017.
And as part of her probation, did she sign conditions of probation?
I'm sorry,
Yes.
correction. It was August 17th of 2015.
Oh. And then as part of being on your caseload, did she sign conditions of probation?
She did, yes.
Did you have an opportunity to go over those conditions and explain to them, make sure she understood them?
I did.
And at that time, did she indicate that she understood each and every condition of probation?
Yes, sir.
Moving to state's motion to adjudicate, count one indicates that Ms. Malicio committed an offense in Covington, Tennessee. Are you familiar with that case?
I'm going to object. That's hearsay, Your Honor.
He's familiar with the case?
Yes, sir.
I'm going to overrule as to hearsay.
Are you familiar with the Tennessee case?
Yes, sir.
And how do you become familiar as a probation officer in general with when a probationer is accused of committing other crimes?
Typically criminal history, or I may receive phone calls. There's different.
And viewing.
At this time, I'm going to object to any line of testimony regarding count one. First off, Mr. Crawford did not make the arrest on this. This was an alleged offense out of the state of Tennessee with an officer who's purported to be named George Finney. He's not testifying here. Okay. That violates Ms. Malicio's rights to confrontation under the United States Constitution, the state constitution, and the Code of Criminal Procedure. Anything that he's relaying at this point is hearsay. He's not a law enforcement officer, so he doesn't fall under the exception in that regard. And so the person who actually is familiar with this offense needs to testify to it so we can cross-examine.
Response, Mr. Rowan.
Your Honor, I've asked no hearsay questions yet. I believe there are some exceptions. I don't intend to ask Mr. Crawford about any specifics of the allegations, just what his direct knowledge is and why it's in the motion to adjudicate.
Court sustains the defendant's objection.
And Officer Crawford, moving on to count two. Count two alleges that Ms. Malicio failed to submit to a UA on January 30th of 2018. Did you order Ms. Malicio to submit to a UA on January 30th?
Your Honor, I'm going to object to anything regarding this count 2 and 3 as part of my motion quash. The counts 2 and 3 do not allege a violation of condition B. Condition B involves injurious type habits. They did not allege that she violated condition L, which is the urinalysis, and any testimony regarding her failure or lack of taking a urinary analysis at this point is not relevant, and we won't give a notice of that. It was simply condition B that they alleged, and that has nothing, that does not require urinary analysis as part of it.
Mr. Harwell.
Your Honor, I believe I can ask some predicate questions to make it more clear for the record.
Well, I want you to respond to what his argument is first. What his objection is.
Your Honor, it's common practice that failing to submit to UA is considered a violation of condition B. It's typically considered a admission of use of injurious habits, use of illicit materials. I believe that the testimony, if given the opportunity to ask, would be that Officer Crawford had the opportunity to explain that to Ms. Malicio, that failure to submit to a UA would be considered same as if she gave a positive UA.
Court overrules the objection.
So Officer Crawford, let me back up just a little bit. When you had an opportunity to go over conditions of probation with Ms. Malicio, did you have an opportunity to discuss condition B?
Yes,
And did you have an opportunity to discuss what failures to submit to UA would be?
yes.
And what did you explain to her about a failure to submit to a UA?
Failure to submit would be seen as a positive UA.
Thank you, Officer Crawford. So Officer Crawford, did you order Ms. Malicio to submit to a UA on January 30th of 2018?
Yes,
Did she submit to that UA?
she did not.
What is the usual course when somebody fails to submit to a UA? Are they, let me be more clear. Are they given an opportunity to make it up?
I mean, they can be, but it doesn't overrule the failure. So even if you make it up, it's still a failure to submit for that specific day and time.
And do you remember offhand, did Ms. Malicio make an attempt to make up that UA?
That day, no.
And Officer Crawford, going to count 3, did you order Ms. Malicio to submit to a UA on March 13th of 2018?
Yes, sir.
And did she submit to that UA?
She did not.
And similar, do you know if she came in to do a makeup?
I don't recall, but no, I would.
And did I understand your testimony earlier that even making it up doesn't negate the fact that it was still a failure?
Yes,
And moving on to count 4 of the motion to adjudicate indicates that Ms. Malicio failed to report to the Van Zandt County Community Supervision and Corrections Department or any other department for the month of December of 2017. Was Ms. Malicio required to report monthly to probation?
yes,
And do some defendants report outside of Van Zandt County?
yes,
And when they report outside Van Zandt County, do you get notification when they report?
yes, sir.
Do you get notification when they fail to report?
Yes, sir.
Was Ms. Malicio reporting outside of Van Zandt County or in Van Zandt County?
In Van Zandt County.
So she would have been required to report to you then every month, including December of 2017?
Yes, sir.
Did she report in December of 2017?
No, sir.
Would there have been another appropriate department for her to report as part of that condition D of her probation?
Said if condition with the
Condition D,
oh,
as in David?
no, no.
So the only appropriate department would have been Van Zandt County.
Yes,
Moving on to count 5. Condition G requires that before a probationer leaves the state of Texas, they get permission. Is that correct?
yes, sir.
Did Ms. Malicio leave Texas without the written consent of the court?
Yes, sir.
Your Honor, I'm going to object. Referring to the court at the time, that's the court take judicial notice that the presiding judge was Teresa Drum. Ms. Judge Drum is not testifying. Anything this refers specifically to written consent by the court, and the only proper person to give testimony regarding that as to whether or not written consent would be the presiding judge. I would object to it being hearsay. We're not allowed. Obviously we're being robbed of our right to confront witnesses under the state and federal constitution, code of criminal procedure. And, um, furthermore, as I said, it's hearsay and it's not relevant.
Right, court understanding the objection and or overrules the objection and finds that this witness is an employee of the court for purposes of supervising those individuals placed on community supervision by courts. So those objections are over.
And Officer Crawford, when written consent is given, do you get a copy of that written consent?
Yes, sir.
Do you have any written consent in your case file for Ms. Malicio?
I do not.
And how is it that you know that she left the state of Texas?
The arrest in Tennessee.
And
I'm going to object. That's hearsay, Your Honor. The court's already sustained our objection to count one.
Court sustains the objection.
Officer Crawford, do you maintain records as a normal course of your conducting business as a probation officer?
Yes, sir.
What, can you give a kind of a description of the kinds of records that you maintain in the normal course of business?
The conversations, we put that in record, phone calls, emails, as I mentioned, we update criminal histories, any kind of contact with any outside entity other than supervision. Basically, just about any handling of the case, we maintain record of that.
And would it be part of your file when law enforcement contacts you from out of state?
It will be part of the record.
Your Honor, again, we're going into areas, hearsay, we're talking about contacts and from a witness who's not present to testify, is not available to testify. That's hearsay, and the court's already sustained my objection to count one. Yet we're still keep going back to this idea of what happened allegedly in count one. I want to re-urge my objection.
I'm going to overrule as to this line of questioning because he has indicated he's trying to prove up a business records affidavit, which he would be authorized to do so.
And as a normal course of your business, did you obtain information that Ms. Malicio left the state of Texas?
Yes.
What documentation do you have that would show that she left the state of Texas?
An offense report.
Nothing.
Your Honor, now referring to evidence that's not within the, or we're referring to documents that have not been admitted into evidence.
I understand. I'm assuming he's going to do so. And the court's going to take that under consideration if he offers it, or if he talks about business records, but he doesn't offer it, then the court will just disregard it.
And Officer Crawford, do you have a copy of that offense report?
In the file, not on hand.
And Officer Crawford, how long would it take to get a copy of that offense report here for the court?
Not long. I almost instantly.
Your Honor, state would request the witness be able to step down to retrieve that report, as he's indicated it won't take long, matter of a couple of minutes.
All right, let's stand in recess for 5 minutes.
Officer Crawford, if you could please obtain that report.
Yes, sir.
Yes. All right, we're back on record in cause number CR 15-152. State of Texas versus Maria Edith Milicio. Go ahead, Mr. Hartwell.
Officer Crawford, I'm handing you what's been marked that states exhibit 1. You have a look at this document. Recognize that, Officer Crawford?
Yes, sir.
And is that a true and accurate copy of the document that you received?
Yes, sir.
And without talking about the accusations in the document, is that the document that you used to determine whether Miss Milicio left the state of Texas?
Yes, sir.
Your Honor, the state would offer State's Exhibit 1 with the limited purpose of how Officer Crawford was tracking Miss Milicio leaving the state, and would not offer it for any of the accusations that are contained within the report.
Right.
Your Honor, any of the information contained in this police report is hearsay. It was generated by somebody else. There's no evidence that Mr. Crawford viewed the original, so he can't testify as to the veracity of the original document. And whether or not this is a true and accurate rendition of the previous one. Further, this has to do with what happened during the traffic stop, allegedly in Tennessee. We don't have it in purports, this, to say that this is Miss Milicio, yet we're not being afforded the opportunity to cross-examine the officer who allegedly generated the report. So we're being, her right to confrontation is being violated, and as a result, her under the state and federal code of criminal procedure, and as a result, she's also being her ability to present a defense is being compromised because, first off, Mr. Crawford testified that he has had this. State didn't turn it over. Okay, so now we violated 3914. I'm going to object under all those things that should, in the testimony regarding anything regarding the alleged incident in Tennessee should come into evidence.
Mr. Hartwell, has this not been disclosed to Mr. White?
Your Honor, it was not part of the records that the state had. State would offer that the probation department is not part of the prosecutor's office. It is directly supervised by the judicial branch of government and accessible by both the state and defense at any time. But no, state did not have a copy of the report to disclose to defense.
Mr. White, did you make a request upon the state for any evidence to be provided?
No, sir. We had a standing order for discovery. As far as I was concerned, Mr. Finney, that's who this Deputy Finney, he's the only one that can testify to this anyway. But now we're trying to get it in, and I think that this is just the state attempting to circumvent the fact that they didn't subpoena the witness from Tennessee to come down here and testify. And now we're still trying to get this in. And any way, however you cut it, police reports are hearsay, whether they're part of some public, whether they try to get it in through an exception or not, it doesn't fit here because it's a police report. And regardless of that, we're still having our rights to confrontation violated.
All right, the board's going to deny the admission of the document on the basis that it was not provided to the defense for them to be able to defend against it.
Yes, Your Honor.
At this time, Your Honor, due to the fact that we weren't given evidently a piece of evidence that they're trying to get in, we're going to ask the court to, at this time, dismiss state's motion to adjudicate in its entirety.
Court denies that request because the remedy is that the court has denied the document sought be admitted by the state. So the rights of the defendant have not been abridged.
And Officer Crawford, going on to count 6 of the motion to adjudicate, it alleges in violation of condition M-1 that Ms. Malicio failed to pay court costs, fine, attorney's fees for the months of September 2017, October 2017, November 2017, December 2017, January 2018, February 2018, and March 2018. How do you track whether a probationer is making their payments to probation for court costs, fines, and attorney's fees?
Yeah, the district clerk's office. We don't keep that record in-house. We have to call over, contact the district clerk's office.
And did Ms. Malicio fail to make payments in those months?
Yes.
Well, Jack, they say that they're not ready to add that to your side.
Sustained.
Your Honor, the state had previously asked, and the court has taken judicial notice of the clerk's file. The payment documentation would be in the clerk's file, as this witness has testified that it is the clerks that keep track of that.
You need to offer that. You need to print that out, show it to defense, show it to the witness. I don't know if he has knowledge of that or not. So if you're asking me to take judicial notice, there's a document that's in there that has been judicially noticed, then it's already admitted. So print it out. Let's show it to everybody.
Yes, Your Honor. And Officer Crawford, while we're looking up that paperwork, moving on to count 7. Condition M2 requires the probationer to pay supervision fees to the probation department. Is that correct?
Yes.
And was Ms. Malicio, as part of her conditions of probation, ordered to pay supervisory fees?
Yes, sir.
How do you track the payment of supervisory fees?
At the probation department.
And are you, do you keep records of that as part of your file?
We do.
And count 7 alleges that Ms. Malicio failed to pay supervision fees for the months of September of 2017, December of 2017, January of 2018, February of 2018, and March of 2018. Did Ms. Malicio make payments on those months?
No.
Your Honor, may I have witness report after this moment?
For what purpose?
Your Honor, they're trying to lay the foundation here regarding his knowledge of payments. However, at this point, I believe Mr. Crawford used the term "we," and that was unclear as to who exactly takes the payments and how they're generated, and who is in charge of the documentation over there. Now, while I will stipulate that under certain, the person who has to testify to this is the custodian of records for the department. And unless he has personal knowledge, and he used the word "we," which doesn't necessarily indicate personal knowledge as to whether the payments were made or not.
All right, I'll grant you for that very limited purpose.
Mr. Crawford, when payments are made, you don't take them, do you?
No, sir.
It's taken by somebody else in your office.
Yes, sir.
So you're reliant upon whoever's in your office to enter that information into the system, correct?
Yes, sir.
You don't have anything to do with that.
No,
Correct.
sir.
So theoretically, a payment could be entered that wasn't made, or a payment that was in fact made might not be entered, correct?
Theoretically, yes.
Your Honor, I don't believe that Mr. Crawford has personal knowledge of this matter. As a result, anything that he testifies is speculative. It's also hearsay, therefore it's not relevant.
They're explanatory.
Your Honor, I apologize. Could I have the objection repeated? I was
In summary, says that this witness does not have personal knowledge to testify as to the payment of fees or non-payment of fees.
Your Honor, I believe we've established that this is kept as part of the probation record, which Officer Crawford is the custodian of. So
Is he the custodian? You'll need to prove him up if you offer him as custodian, rather than just making that conclusion.
yes, sir. Officer Crawford, do you keep and maintain a record of each and every one of your probationers?
Yes,
As part of maintaining those records, are you given reports?
yes.
And do you file those reports into a probationer's file?
I'm not sure I'm clear what you're asking.
When you receive a report, say a payment report, what do you do with the receipt or report for payment?
It's filed automatically in our system. We have a conjoined system,
It's
so
automatic.
it's automatically filed. Yes,
And as part of maintaining that record, do you review it for accuracy?
yes.
Can you tell the court what you do to review a file for accuracy?
We can get into the individual's case and click on certain reports, or it'll have a payment made option, or and we can look at the records that are that we need to access in our system.
And did you do that with Ms. Malicio's file?
Yes,
And as part of checking for accuracy, is that when you discovered that Ms. Malicio missed payments?
I want to check, this is hearsay, he didn't put those in, he still hasn't been proven up as being the custodian of records for the Van Zandt County Community Supervision and Corrections Department. And as a result, Mauricio was not able to effectively cross-examine the witness. In addition, right to confrontation. Because again, he's not the one who generated it, is responsible for making the records or testifying.
Sustained as to proper predicate or custodian of it.
So, Your Honor, state would offer as, I don't know, do you just court wanted as State's Exhibit 1 or 2 since 1 was denied? This is a,
Yeah, you've already referred to State Exhibit 1, so you need to mark it as something else.
yes, sir. State offers State's Exhibit 2, a certified copy of the bill of costs in the clerk's file.
Any objections, Mr. White?
Your Honor, I'm sorry to have.
Yes. Or you can just write it on there, whatever's easier.
Your Honor, this document doesn't evidence anything as far as what her state has alleged in their motion, certain dates. This document does not allege any dates at all. All it has is, evidently that it was made this day. It doesn't show when it was actually, when these
Let me see the document so I can refer to that while he's talking about it. Go ahead, Mr. White.
it doesn't. I mean, first off, I don't see where it's relevant in that it doesn't reference any of the timeframes that the state has listed within their motion. And as a result, you know, we're depending on the fact that this particular document, again, that what was entered into it was entered in correctly, and we don't have anybody testifying that was done so. So now we're back down to.
Hang on, let me ask a clarify question. What purpose is this being offered for, Mr. Hartwell?
Your Honor, for count number 6, failure to pay court costs, the fact that there is, I'm sorry, Your Honor, I'm pulling up a copy on my computer as well. Your Honor, as evidenced at the top of the document there, the amount that is owed along with the balance at the bottom, that balance indicates that no payments have been made at all. If payments have been made, that balance would be reduced by the total amount or would be zeroed out if all payments had been made. The fact that the balance remaining is the entire balance owed indicates that 0 payments were made.
All right, court overrules the objection. And State's Exhibit 2 is admitted.
And Officer Crawford, the violations we've discussed so far, did those violations of probation occur during the probationary period?
Yes, sir.
Did any of them occur outside of the probationary period?
No, sir.
One final question. When ordering Ms. Malicio to take those urinalyses on January 30th and March 13th, do you recall how she was directed to take those UAs?
I can't say specifically, but typically, verbally, it would be in office. If she's in office, I would tell her verbally.
I want to object as to his testifying. Now he's speculating what he did with Ms. Malicio. If he doesn't remember correctly, I don't believe he should be able to testify to it.
Overruled.
Your Honor, State passes the witness.
Do I hear witness?
Yes, sir. Mr. Crawford, now, in counts 2 and 3, we talked about Ms. Malicio allegedly violating condition B of her probation. And would you agree with me that you're familiar with the conditions of probation in this case?
Yes, sir.
Okay, these were pretty standard conditions. Would you agree with me on that?
Yes, sir.
And you've been here, you said 12 years.
Yes, sir.
Now, I think there's been a change to the probation conditions here and there, but they're pretty much the same as they've been since you've been here, correct?
Yes.
And so condition B has to do with avoiding injurious and vicious habits, abstaining from the use of alcohol beverages, etc. Correct?
Yes,
Now, within that condition doesn't stipulate that she submit to a urinary analysis, does it?
it's been used both.
It
Both,
doesn't state that, does it? That she has to submit, correct?
no, sir.
In fact, it's stated in condition L that she has to submit, correct?
Yes,
Okay, now, as far as submitting to a urinalysis, you agree with me that if the failure of somebody, if somebody can't urinate within a prescribed period of time, that would be failing to submit to urinalysis, correct?
yes,
Now, that doesn't necessarily mean that the person has anything in their system, does it?
no, sir.
And that would be why we have we got one that says you're not supposed to do certain things, but the other one you have to submit, correct?
Yes,
So they're two different conditions, correct?
yes,
And they're two different distinct conditions, correct?
yes,
Now, in count 4, state has alleged that Ms. Holyfield failed to report to our department or any other department, correct?
yes,
Now you didn't call Wood County and see if she reported there, did you?
no, but
Did you call Smith County?
no,
Did you call any other department in the state of Texas? Other 253 other counties?
no,
Okay, and you would agree with me that it says that she couldn't, it says that she had to report here or any other department, correct? But you have no personal knowledge as to whether or not she did or not do.
no. But it wouldn't matter.
Objection, Your Honor, non-responsive.
Sustained, non-responsive as to the last thing.
Now, within the probation conditions, there's numerous mentions of the Van Zandt County Community Supervision and Corrections Department, correct?
Yes,
And there's also within there, it refers to the court as well, correct?
yes,
And many times, for example, in, let's just say, there are parts within, or is language within the conditions of probation where we refer, as I said, to the court and to the department. Is that right? In other words, the department at the direction of the court does things, correct?
yes,
Now, as far as condition number, G goes, it only refers to the court, is that correct?
which condition was,
That's the one where it says remain in the state of Texas unless you first secured the written consent of the court to leave therefrom, correct?
yes,
Now, that specifically refers to the court, is that correct?
yes,
Now, in this situation, that means that she's got to get permission from the sitting judge in order to leave, correct?
No. We give out the travel permits, like I said, acting in direction from the courts. So we give out the permits.
Okay, so what you know is y'all didn't do it, but you don't know if the court did.
Yes, true,
That's correct?
great.
And to be specific, that particular condition only refers to the court and it doesn't refer to any other part where the department is acting on behalf of the court like it does in other parts of the conditions, correct?
Yes, sir.
Now, when y'all receive a payment, you had said that y'all receive the payment and I'm supposing that somebody up front receives it, enters it into the system, correct? Is that your understanding?
Yes,
And when somebody comes in to make a payment, what kind of payments do you accept? Or does the department accept?
money order or a debit or credit card.
Okay, and then that money is put into where? Is it credited to their account?
Yes, and it says it gets credited to the system in the account. Yes.
And when the payments are made, like in count M1, it has court costs, fines, attorney's fees, all in M1. Is that correct?
Yes.
Now, I'm assuming, and I'm not going to hold you to this, if you need to review something, just tell me. But if somebody is unable to pay, what's supposed to happen?
I'm not sure I understand the question.
Let's say somebody's not able to make their payments. When somebody comes in to meet with you, do you make a determination about their ability to pay?
You mean if someone comes in and they can't pay or they don't pay, like what
So-
do I think of that? Or I'm still not
Oh,
really
okay,
understanding.
and I'm asking a back question, I'm sorry. Are you familiar with Article 42A 655 of Code of Criminal Procedure, ability to pay?
No, sir.
So when somebody comes in, does the department make at the direction of the court any determination as to whether or not the defendant has sufficient resources or income to make payments under probation?
No, I mean we can, but no.
Y'all don't do it. Okay.
It-
And of course, that excludes restitution. During the, during this period, so you don't make under 42A 655 any determination about the ability to pay out of your office.
I'm not familiar with the code. What is it specifically?
Let me
read?
get. You guys have a copy?
You may.
Practice that. Your Honor, at this time, part of the code of procedure, and I've got a copy of the code, like a copy, I'm gonna ask for the judicial. Code of criminal procedure, article, 42A, 655.
Any objection to the state?
No objection, Your Honor.
All right, court does the judicial notice of that statute.
So as far as you know, and you didn't make that determination about her ability to pay this.
From what I'm seeing, it says maybe she has to present an argument that she can't make the payments because under our conditions, she signed and agreed to make those payments.
I understand, but that she can bring that up at a later time, but initially when she goes on probation, there should be that determination, correct? Whether or not she can do it.
Well, I think that should be done before being placed on probation.
This situation, you didn't make that determination, did you?
I did not know, not before she's placed on probation.
And you're aware and you've testified that she didn't make attorney's fees, correct?
Yes,
And when somebody's appointed an attorney, that means that they're indigent, correct?
yes,
So when she came in there, everybody knew that she was indigent, right?
yes,
And you said that y'all acted at the behest of the court, correct?
yes,
And that y'all are employed by the court.
yes,
And you agree with me that it says notwithstanding any other law subject to say subsection C, which has to do with restitution, the court shall consider whether or not the defendant has sufficient resources or income to make payments under this chapter, excluding restitution. And then it goes down the deal. And y'all are acting on behest of the court, correct?
yes.
So at the time that she was in there, immediately upon being placed, there should have been a determination by the department as to whether or not she could actually make those payments, correct? Under the law.
I guess you can make that argument.
I'm not making that, that's what it says.
Well, it still says, before receiving,
Now, she can request it any time to. But at the initial time that she made, nobody made that, make it, did you?
she didn't make a request either.
Well, I didn't say that she didn't make a request. At the time she came in,
Mhm.
you did not make a determination.
No,
Mr. White, where does it say under 42A 655 that the probation officer shall make that determination?
Well, Your Honor, they testified that they act on behest of the court. They work for the court.
Right, but where does it say the probation
It
officer?
doesn't say the probation officer.
It says the court.
It says the court.
So what's this line of questioning? It's not incumbent upon him statutorily to do it. It's incumbent upon the court to do that.
Well, I understand that, Your Honor. But they say they act on behest of the court, and we let evidence in that, you know, as far as the written permission to leave the state, that they act on behest of the court. And
Well, they enforce the court's conditions, but I'm saying, where does it say in this article?
You're not right, it doesn't say that.
Okay.
They act on behest of the
I understand, but you're asking him if he did it and implying that it's a violation of his duties to not have done that. When the statute doesn't place that on him, it places it on the court. If it's a violation of anyone, it's a violation of the court, not a violation of the.
Almost. Are you aware of whether or not Judge Riley made that determination when she was on probation? She placed on probation,
no, sir.
okay? And you do know that she was indigent, she had attorneys, correct?
Yes,
Now, when we start getting over there, the condition M1 has within it court cost, attorney's fees, and fine, correct?
yes.
Now, I'm sorry about that. Not my statement.
No, go ahead.
There's a little bit of a difference between how fees, fines and restitution. You agree with me on that?
Said how they're viewed
Yes, under the code,
under this code, or
under the code of criminal procedure, as far as payments go.
I'm not sure.
Okay. So when somebody, kind of back up, when somebody comes in and makes a payment, she was supposed to make a payment of, according to the conditions, of $50 a month. That sound right?
For the restitution?
No, for the under M1.
Okay, I don't have a copy of it, but that,
And that has, I'm gonna give you a copy of this, just let you look at it so you can look. Yeah, you may. So that's it.
thanks.
That has court cost, fines, and attorney's fees, is that correct?
Yes, sir.
And there's a different, M2 has to do with a different type of fee, which is like supervision fee, correct?
Yes, sir.
Now, somebody is unable to pay, or when somebody comes in and pays, the department puts that into a system, is that correct?
If they make the, you said if someone comes in to pay, yes, sir.
The defendant doesn't have any choice as to how those payments are applied, does the defendant? As to what they're applied to.
I'm not sure, honestly.
So you don't know, that's what you're saying?
Yeah.
Okay. Now, under the law, if somebody's not able to pay their fees, court cost, are you aware that the state now has a burden, depending on the situation, as to having to prove the inability to pay? Are you aware of that?
No.
Okay. Are you aware that the fine amount is excluded from that?
No, sir.
So would you agree with me that if somebody was paying, they would probably want their money to go towards fines and restitution because it's excluded? You know, whether you pay those or not, there's a different burden.
Yeah.
At the state. So they would probably want their fines and those things paid off because they can have the others excused, possibly, correct?
Possibly. I mean, that depends on the person.
But they don't have that choice, do they?
I'm not sure.
Okay. Well, it's all put into one condition, correct, in one. So would you agree with me that we've got one type of financial obligation that possibly could be excused and one in the same condition that can't be excused?
Yes.
And that's what it's on.
Real well.
Thank you, Your Honor. Officer Crawford, if a probationer comes in and they're unable to give a UA, does that happen from time to time?
Yes.
And when that happens, do you give any kind of accommodations? Are they expected to deliver a UA immediately or
Yes. They have 2 hours.
2 hours? And if you're watching them and they're drinking coffee, drinking water, and they still just can't give a UA, would you consider it a violation if they went a couple more hours and still gave one the same day?
No.
And did Ms. Malicio ever request an accommodation for giving a UA?
No,
And earlier we discussed Ms. Malicio reporting to the Van Zandt County Probation Department. If Ms. Malicio did report to, say, Smith County, would that count as a monthly contact for you?
no,
Did, uh, did you explain that to her when you went over conditions of probation?
yes,
Uh, And Your Honor, state offers certified copies of the conditions of probation and an amendment to the conditions of probation that are in the clerk's files. As states, exhibit 3 for the conditions of probation and states 4 for the amendment.
Any objections, Mr. White?
I have no objection. Hold on a second. Your Honor, I'm sorry, I'm cross-referencing something real quick. Your Honor, I don't have any objection to pursuing subject to any other hearsay evidence. I don't want to wait those reasons.
All right, court admits states exhibit 3 and states exhibit 4 as certified copies of records that the court has taken judicial notice of as being contained in the contents of.
Thank you. And may I approach the I'll talk about the states 3 and 4. On states 3, that is a copy of the conditions of probation. We just went over in cross condition M1, the payments at a monthly rate of $50. Did I understand that exchange correctly?
yes, sir.
Can you look to states exhibit 4? And in states 4, paragraph 1, where it's beginning with court costs, can you see whether the rate at which he was to pay changed at all?
Yes, you told me, condition 1 is what you're referring to.
Yes, sir.
M1.
Under condition M, just that paragraph with the
Yes.
paragraph 1.
Yes, sir.
And what was the new payment on that amended condition?
$100 a month.
And did the court at any point ask you to make a determination of Ms. Malicio's ability to pay?
No,
Did Ms. Malicio ever express to you an inability to pay?
Not that I recall.
If she did, would that be something that you document?
Yes,
Do you have documentation of that?
not on me.
Your Honor, I'm object to the state referring to, now we're referring to the things in the state's possession through the department with one of their witnesses. We had to begin. Object to anything as far as his notes or anything of those written recollections without the proper use of, without properly laying the foundation to get those observations in, that's hearsay. I don't object to his testimony, and that's the court disregarded.
Your Honor, I'm not asking the witness to refer to his notes. I'm just asking if he would have made a note.
Court overrules the objection.
No further questions. Your Honor, state passes.
That's right.
State ever asked you to turn over your probation file to them?
Like the notes, the chronos? No, sir.
And you have those?
I do, yes. Like, again, not on me, but
Not on.
Yeah.
Did you refer to those before you came over here today?
I did, yes, sir.
I hate to do this, Your Honor, but I want to go through those.
All right, court's going to break for lunch. We're going to stand in recess and we will resume at, we'll resume at 2:30.
And I do have a plea assignment, so I'll go out and get that signed up and I'll be back here.
Yeah, I expect our contested hearings to start back at 2:30 over here, so I'll allot it an hour for Zoom. All right, we're in recess.
Good afternoon, Your Honor.
Good afternoon. We ready to go?
We ready?
All right, who'd like to call first?
Michael Whitten.
This is cause number CR 24-9, State of Texas versus Michael Joseph Wooden. Motion to revoke. Go ahead, Mr. Schmidt.
Judge, working with the state, I'm gonna ask for one final setting on Mr. Whitten on the next contested docket.
Objection?
No objection, Your Honor. Thank you.
All right, court sets Mr. Witten for a final hearing on his motion to revoke, April 29th at 1:30.
As quick as possible. It's Jacob Myers.
Jacob Wyatt Myers, cause number CR 23-30.
And Judge, this is a motion to adjudicate. We've reached an agreement with the state wherein they've agreed to withdraw their motion to adjudicate, continue Mr. Myers on community supervision, amend his terms of community supervision to include 67 days in the county jail as a condition, credit for that time, as well as additional costs for the motion to adjudicate.
Right, and this has been approved by the probation department.
Yes, sir.
And Your Honor, I do have that motion. I just printed it, so I'll have it to the court here shortly.
Mr. Myers, sir, if you'll raise your right hand, I'll place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, nothing but the truth, so help you God?
Yes,
All right, you can lower your hand. Mr. Myers, you heard Mr. Schmidt, your attorney, state what the agreement is between you and the DA's office regarding your violation, your alleged violations on your motion to adjudicate. Are you pleased with Mr. Schmidt and the work that he's done as your attorney?
yes, Your Honor.
Do you have any questions about that agreement?
No,
And so, in your own words, Mr. Myers, tell me briefly why I should allow you to continue on community supervision.
I believe that I can do it right this time, and it is time for me to man up and be able to prove that I can do this. And I think that I'm able to, and I want to be able to just prove it to the courts.
You understand, Mr. Myers, that another motion alleged by the state court might not allow y'all to enter an agreement. I may just have to have the motion heard and make a determination to see if you violated it or not. You understand that?
Yes, Your Honor.
All right, has anybody threatened you, forced you, or pressured you to make an agreement to withdraw and continue your community supervision and amend your conditions to require 67 days confinement in the county jail, to which you would get credit for time served, and also the imposition of new attorney fees, the amount of $500? Has anybody forced you to make that agreement?
No, sir.
All right, court will approve the amendment to the conditions of community supervision, and the court hereby grants the state's motion to withdraw the motion to adjudicate. All right, so Mr. Myers, let this be the last time you show up in court like this.
Yes,
All right. Step over and you can sign your paperwork with the probation department.
The only other I have is Cabrera Alonso. We're waiting on interpreters for that one, so I believe that's at 2:00. Whoever needs to get it.
You'll let us know when either Hunt County or the interpreter.
Okay, is Mr. Manning ready on anything?
No, we're still going over some pleas.
Okay.
Are you ready, Your Honor?
Yes, we're ready. Before we begin though, can you have Mr. Cabrera get closer to the camera so that?
Yes, sir.
Excellent. And Holly, if you'll go ahead and see if you can get a line of communication. All right, and for the record, the state has, the court has already sworn in Ms. Holly Bill as a licensed master court interpreter earlier today, so she is still under oath for purposes of this hearing. And this is cause number CR 21-00207, State of Texas versus Carlos Cabrera Alonso. I think we're set for motion to revoke hearing today. Mr. Schmidt, any announcements?
Yeah, Judge, we've been in, communications with the state. They made an offer. I'll relay that to Mr. Cabrera Alonso. We're gonna accept that offer and we'd ask to set him for a plea on that April 29th docket.
April 29th. Okay.
Yes, sir.
And can you go ahead and state what the plea is so I can get affirmation from Mr. Cabrera Alonso before we set it?
Yeah, yes, sir. Upon his plea of true to the allegations, the state's recommending that he be revoked and sentenced to 12 months in the state jail facility. And obviously he'll get his credit time, and I've told him his current credit time. That'll be an additional 30 days or so when we get here in April.
Okay. And Mr. Cabrera, is that your understanding of the agreement? Very well. All right, then the court sets Mr. Carlos Cabrera Alonso for plea before the court on April 29th at 1:30. I'm sorry, we'll do it at 2 p.m. that day, Mr. Schmidt, so that we can make arrangements for court interpreter.
Yes, sir.
Okay, gracias.
All right. And Ms. Bill, I believe that is all we have this afternoon. Yes, ma'am. Thank you for being here again. Appreciate it.
John.
Your Honor, do you have the electronic papers for Mr. White?
No, ma'am.
No.
Well, hang on. Let me check. It might have gone to spam. It's been doing that. It goes to my inbox, and every other time it goes to another folder. Is this on Mr. Wigington?
Yes, Your Honor.
I do have.
Okay, then we're ready when you are.
Yeah, go ahead and bring him up. This is cause number CR 23-228, State of Texas versus Caleb Allen Wigington. Mr. Wigington, if you'll raise your right hand, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir, Your Honor.
All right, you can lower your hand. Mr. Wigington, United States citizen who reads, writes, and speaks English?
Yes, sir.
Have you ever been diagnosed with a mental condition?
No, sir.
In this case, you're represented by your attorney, Mr. Nolan White. Are you pleased with Mr. White and the work he's done as your attorney?
Yes, sir.
Do you have any questions about anything regarding this case or your plea agreement or anything else?
No, sir.
Okay, Mr. White, have you explained to Mr. Wigington his rights as they pertain to this case?
Yes, sir. I've explained to Mr. Wigginton what his rights are. I believe he's waived those rights knowingly, intelligently, and voluntarily. If the court will know, the court accepts the plea agreement, Mr. Wigginton or the state will be proceeding under 1244A. And I've explained to Mr. Wigginton that that is a felony conviction, just like any other felony conviction, and that he will be a convicted felon as a result of this plea of guilt. I'm satisfied that he understands that.
Thank you, Mr. White. All right, Mr. Wigington, you are charged by indictment with a state jail felony offense of possession of a controlled substance in penalty group 2, less than 1 gram. That does carry a range of punishment of not less than 6 months in prison up to a maximum 2 years in prison and a fine not to exceed $10,000. I do see the plea agreement in this case, as Mr. White has stated, is upon your plea of guilty to that crime. The state is recommending that the prosecution go to a 1244A, which is what Mr. White has said you would be convicted for the offense, but your punishment would be assessed under that of a misdemeanor punishment range, a Class A misdemeanor. So that reduced range of punishment would be up to a maximum 365 days in the county jail and a fine not to exceed $4,000. In your plea agreement, upon your plea of guilty, the state is recommending that the court consider the evidence, convict you of the offense, assess your punishment at 30 days confinement in the Van Zandt County Jail, to which you would get credit for 8 days of time served. In addition, they're recommending a $500 fine plus court costs and reimbursement fees. And they are also agreeing to dismiss a few unfiled cases of possession of marijuana less than 2 ounces, and actually just one case. And you would have the remainder of your sentence to serve. So you'd have 22 days to serve. Is that your understanding of the plea agreement, Mr. Wigington?
Yes, sir.
Very well. All right, sir. How do you plead to possession of a controlled substance in penalty group 2, less than 1 gram?
Guilty.
Are you pleading guilty to that crime because you are in fact guilty of committing that crime?
Yes, sir.
And Mr. Wigington, has anyone threatened you, forced you, or otherwise pressured you to plead guilty?
No, sir.
The court does accept the defendant's plea of guilt at this time. Mr. White, any objection to the evidence supporting the plea?
No, sir.
All right, the stipulation of evidence is admitted or takes judicial notice of the defendant's judicial confession. Anything further from the state?
Nothing further, Your Honor. Thank you.
Anything further from the defense?
No, sir.
All right, the court's going to consider the evidence. All right, the court, having considered the evidence, finds that there is enough evidence to convict the defendant of this offense. The court will follow the plea agreement. Court hereby convicts Caleb Allen Wigington of possession of a controlled substance in penalty group 2, less than 1 gram. Court assesses punishment pursuant to section 1244A of the Texas Penal Code at 30 days confinement in the Van Zandt County Jail. Mr. Wigington is awarded 8 days credit towards that sentence to serve the remainder of that sentence. Further, the court assesses a $500 fine, court costs of $290, and reimbursement fees of $35. The court does dismiss under section 1245 unfiled DA cause 2023-686, possession of marijuana less than 2 ounces. Mr. Wigington, you're hereby remanded to the custody of the sheriff so he can carry out the terms and conditions of the sentence. I'm going to have you step over to be fingerprinted, and then you'll be taken into custody. Mr. Wigington, when you get out of jail, if you've not made arrangements to have your fine, court costs, and reimbursement fees paid off, you need to report to the courthouse, go to the district clerk's office, and ask for a payment plan to get those things paid for. If you do not do that, the court could issue an arrest warrant for you for your failure to pay your fines and fees, okay?
Yes, sir.
All right, thank you, sir. Step over with the bailiff.
And Your Honor, I'm headed over your way now.
Yes, sir. Sounds good.
You're talking about one scene.
Yeah, I speak. It's an individual.
That's that one individual line,
Okay, so 50 plus.
and then the group each week.
50 plus. 80.
So,
Your Honor, do we have Hunt
that's
County
weird.
yet?
No, ma'am.
No.
Well, 20, no, one night, so 20 times 4 is what? 80? Plus the.
Okay, Mr. Manning's ready.
Who's he ready on?
Ready, Mr. Hagan?
All right, this is cause number CR 22-180, State of Texas versus Jeffrey Ray Hagan. Is this a plea today?
Judge, the state has tendered a motion to withdraw and extend. Part of the conditions that'll be amended are that he's going to participate in safety as a condition of probation. Additionally, they also modified the court cost to update the recent addition of attorney's fees.
Mr. Hagan, sir, if you raise your right hand. Sir, do you swear that the testimony you give to the court will be the truth, the whole truth, and nothing but the truth, so help you God?
Always, Your Honor.
Thank you, sir. You can lower your hand. Mr. Hagan, is that your understanding of the agreement that Mr. Manning just stated, that you're agreeing to amend the conditions of your community supervision and have the substance abuse felony punishment facility as a condition? And also the amendment of your financial obligations to include additional court costs and attorney fees?
Yes, Your Honor, that's correct.
And has anybody threatened you, forced you, or pressured you to make that agreement here today?
No, Your Honor, they have not.
Are you pleased with Mr. Manning and the work he's done as your attorney?
He's done a fine job, Your Honor.
All right. Do you have any questions about anything else?
No, Your Honor, that covers it, and I appreciate it.
And Judge, one of the questions Mr. Hagan did have was in regarding his finances with him being in safety. And I told him that the probation department would obviously be aware of that and would not begin assessing those until he does get out of safety when he completes that.
Correct. And so there will be no collection efforts by the county on financials as long as Mr. Hagan is in the substance abuse felony punishment facility. Is that your question?
Yes, as long as it said the payments to begin April 2025, and obviously I won't be out to make the money until. Yeah.
Yes, sir. Yeah, we'll be aware of where you're at, and once you're there, there will be no collection efforts regarding any of your fines and fees. And the probation department's not going to hold against you that you're in safety and that you didn't make some kind of financial payment in April or May or June or however long.
Right, you know, I was just making sure there wasn't gonna be a balloon payment when I got out that would cripple me on some kind of balloon payment on it.
No, probation department's going to work with you.
All right, thank you very much, Your Honor.
You're welcome. All right, Mr. Hagan, step over to sign your conditions and work hard and safety.
Yes, sir, I sure will. Thank you.
You're welcome. Have a good day. put this on the record. And Mr. Manning, I don't think I put it on the record, but the court hereby does grant the state's motion to withdraw and amends the conditions of community supervision for Mr. Hagan to include safety and the additional court costs and attorney fees.
Thank you, Judge.
Ms. Hampton?
Yes, Judge.
All right, this is cause number CR 20-390, State of Texas versus Hannah Marie Hampton. Are we doing a plea today, Mr. Manning?
Yes, Judge. I apologize for the delay. We had to amend the amendments of probation. Ms. Hampton is going to agree to, upon withdraw and amend a 3-year extension, ISP as a condition of probation, the new attorney's fees. Additionally, she's going to be serving 120 days in jail as a condition of probation with credit for 94 days. And the remaining 26 days are going to be served in a schedule that's outlined in condition N. And basically that schedule is after group session on Tuesday evening she'll turn herself into the county jail at 7 p.m. and she'll be released on that Thursday at 7 a.m. and that will continue until her 26 days additional has been served.
Okay. Ms. Hampton, if you'll raise your right hand. Do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, you can lower your hand. All right, so Ms. Hampton, you heard the agreement that you've worked out with the state, the DA's office, as Mr. Manning has stated it on the record. Did you hear that?
Yes, sir.
Is that your understanding of what you're asking the court to approve today?
Yes, sir.
All right, and you understand, Ms. Hampton, if the court approves this, that should you ever be subsequently revoked and sentenced, that you would not receive any credit for the 120 days that you will be serving against any future sentence. Do you understand that?
Yes, sir.
Okay. And Ms. Hampton, are you pleased with Mr. Manning and the work he's done as your attorney?
Yes, sir, I am.
Right. And has anybody threatened you, forced you, or pressured you to make an agreement here today?
No, sir.
All right, the court will grant the state's motion to withdraw the motion to revoke. The court hereby amends the conditions of Ms. Hampton for an additional 3 years of supervision. Court orders her to be placed on the intensive supervision program, orders her to pay new attorney fees as associated with this motion to revoke. Further, the court imposes 120 days as a condition of community supervision. The court will award Ms. Hampton 94 days credit towards that sentence, and the remainder shall be served as laid out in the schedule filed in the papers of this cause. All right, Ms. Hampton, step over to sign your amendment.
Yes, sir. Thank you.
You're welcome. Mr. Abraham, there's still no Hunt County, just so that you're.
Judge ready, Mr. Cromwell.
Mr. Cromwell, if you'll come forward. This is cause number CR 24-309, State of Texas versus Philip Shane Cromwell for pretrial. Go ahead, Mr.
Judge, I have an announcement in terms of, at this point in time, I don't believe that we have received all the discovery in this case. I've consulted with the DA's office and I think we're still missing a couple items. However, my client has requested that he have a speedy trial and has requested to be set on the trial docket. I've explained to him that once we advance past docket call, that there would not be opportunity, the court may not entertain any future plea recommendations or offers, that we may be stuck with what he's asking for, which is a trial. He said he understood that and wishes to proceed on this case.
Very well. Court will, I'll take that under advisement until we get to a docket call announcement. And so we're gonna, before we set this thing for trial, we're gonna make sure that we have all of the pretrial issues taken care of. So State you're aware of what it is that Mr. Manning's requested regarding the pretrial discovery.
Yes, Your Honor. I believe that, and correct me if I'm wrong, Mr. Manning, I believe it's going to be medical records, which are still being kind of compiled. I spoke with the Justice of the Peace in Hunt County who did the inquest. So he, had just finished filing some of his paperwork, so we're still waiting on some of that stuff to come in. As soon as it is in, Your Honor, we'll be sure to get that over to Mr. Manning as soon as we can.
Is there anything in addition to medical records, Mr. Manning, that you're waiting for?
Not that I'm aware of at this time. I will let the court know that the state has provided voluminous records regarding this case. It's just without a cause of death by a medical examiner. That's kind of the key piece that we're waiting on.
Okay, so what we'll do is we'll set this for docket call on May 1st. And on that day, should we have all pretrial issues settled, then we'll talk about a date that we'll set for trial.
This judge. And Judge, I apologize. What was the date that was given for that reset?
May 1st.
Thank you, Judge.
Who would you like next?
Judge, if we can bring up Mr. Justin Guyton.
You're not going to be a contested hearing in the courthouse?
Judge, no, I was speaking to Ms. Abraham earlier. They were having some transportation issues, and after reviewing my motion over the lunch period, I'm going to ask the court to take that under abatement at this point in time, due to there possibly being a better vehicle to deal with this legal issue. And so I'd ask the court to take the motion to suppress that's currently on file, that was timely filed, under abatement, and we reset for the contested docket in April.
All right, and cause number CR 24-54, State of Texas versus Justin Dramel Guyton. Is there any objection from the state regarding the defense request to continue the evidentiary hearing until April?
No objection, Your Honor.
All right, there being no objection, then that motion is carried to April 29th at 1:30.
And Your Honor, not to take things out of order, I didn't know that there were transportation issues. We may be able to resolve Ms. Saunders as well. I know that was going to be a restitution hearing. To let the court know we spoke with victim, let him know that he needed to be here for the hearing, said he wasn't going to be comfortable coming and that he would not be here today. So we learned that. I don't know if it's helpful at this point, but if there are transportation issues, Your Honor, our victim that was going to be testifying to prove up restitution is not going to be here.
Was the state going to put on any other evidence regarding restitution?
Your Honor, without him here to lay the foundation, I don't think we could get that evidence in.
Okay, so there'd be a claim of zero restitution?
Correct, Your Honor. And we explained that that was a distinct possibility if he did not show up, and he still said that he was not comfortable coming to court to testify.
You heard all that, Mr. Green?
Yes, Judge, and Ms. Abraham is going to let the jail staff know that she won't need to be transported over.
All right, so we're going to put this on the record. This is cause number CR 23-40, State of Texas versus Haley Delane Saunders. Ms. Saunders have already pled to the court. The court, however, took the issue of restitution under advisement, and that was set for a hearing today. The court having been informed by the state that it does not have any evidence to present on that matter, and that the victim in the case did not appear today to testify, despite being noticed of his requirement to do so. So the court hereby finds that there is no restitution owed in the judgment adjudicating guilt. So Ms. Sanders is eligible then to be transferred to the Texas Department of Criminal Justice. Ms. Abraham, if you'll let the jail staff know that there's no longer a hold on her and that her case has been disposed of.
There's no hold on her, so she can be processed. She can be good. Judge, have you received the paperwork on Mr. Walls at this point in time?
Yes, I have.
Okay, would you like to go forward with him?
Yes, sir. Sounds good. All right, this is cause number CR 25-0027, State of Texas versus James Christopher Walls. Mr. Walls, sir, if you'll raise your right hand. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
All right, thank you, sir. You can lower your hand. All right, your name is James Christopher Walls, is that correct?
Yes, Your Honor.
And Mr. Walls, are you a United States citizen who reads, writes, and speaks English?
I am, Your Honor.
Have you ever been diagnosed with a mental condition?
No, Your Honor.
In this case, you're represented by your attorney, Mr. Jonathan Manning. Are you pleased with him and the work he's done as your attorney?
Yes, Your Honor.
Do you have any questions about your plea agreement or anything else regarding this court matter?
No, Your Honor.
All right, Mr. Manning, do you believe Mr. Walls to be competent? And if so, have you explained to him his rights regarding this case?
I do, and I have.
And do you believe that he is entering into this agreement intentionally, knowingly, and voluntarily?
Yes, Judge.
All right, Mr. Walls, I see that you are indicted with a third-degree felony offense of stalking that does carry a range of punishment of not less than 2 years in prison up to a maximum 10 years in prison and a fine, if imposed, not to exceed $10,000. I see also that the state of Texas had enhanced your indictment with a prior conviction in which part of the plea agreement today, it appears to be that they are going to abandon that enhancement allegation. And their recommendation in the plea agreement is upon your plea of guilt, they're recommending that the court consider the evidence, convict you of this offense, and assess your punishment at 6 years confinement, Texas Department of Criminal Justice Institutional Division. In addition, they're asking the court to impose a fine of $3,000, $290 in court costs, and $20 in reimbursement fees. Is that your understanding of the plea agreement, Mr. Walls?
Yes, Your Honor.
And Mr. Manning, do you know what credit time Mr. Walls would have as of today?
Yes, Judge. I confirm with my client the calculations by the DA's office which showed that he had 151 days credit as of today.
Thank you, sir. All right, Mr. Walls, understanding the plea agreement and the range of punishment, how do you plead to the third-degree felony offense of stalking?
Guilty, Your Honor.
And Mr. Walls, are you pleading guilty to that crime because you are in fact guilty of committing that crime?
Yes, Your Honor.
And has anybody threatened, forced, or pressured you to plead guilty?
No, Your Honor.
All right, the court does accept the defendant's plea of guilt at this time. And Mr. Manning, any objection to the evidence supporting the plea?
No objection as offered, Judge.
All right, stipulation of evidence is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
Your Honor, only that state is in compliance with victim contact. Nothing to report from the victim.
Thank you, Mr. Arwell. Anything further from the defense?
Rest and closure, Judge.
All right, court's going to review the evidence. All right, the court having reviewed the evidence finds sufficient evidence to convict the defendant of this offense. Court will follow the plea agreement today between the defense and the state. Court hereby convicts James Christopher Walls of the third-degree felony offense of stalking, assesses punishment at 6 years confinement in the Texas Department of Criminal Justice Institutional Division. Court finds that the enhancement allegations have been abandoned. Further, the court assesses a fine of $3,000, court costs of $290, and reimbursement fees of $20. And Mr. Walls will be awarded 151 days credit towards his sentence for the time that he has spent in jail on this cause. Mr. Walls, you're hereby remanded to the custody of the sheriff so they can carry out the terms and conditions of the sentence. When you are released from TDC, if you have not paid off all of your fines and fees, you'll need to report to the courthouse to make a payment plan. Do you understand?
Yes, Your Honor.
All right, if you'll step over to be fingerprinted, good luck to you, sir. Mr. Rainey, who you ready on?
Judge ready on Tyson Davis.
Come on up, Mr. Davis. Davis, sir, if you'll raise your right hand, I'm gonna place you on oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir, Your Honor.
Thanks, sir. Lower your hand. All right, this is cause number CR 24-310, State of Texas versus Tyson LaCruz Davis for pretrial. Go ahead, Mr.
Judge, at this time, we have no contested pretrial issues or ask to be set on docket call.
All right, there being no contested pretrial motions, the court sets this for docket call on May 1st at 1:30. Who'd you like next?
Judge, next ready, Jonathan Dickerson.
Jonathan Lee Dickerson, cause number CR 25-7 for pretrial.
Judge, at this time, we have no contested pretrial issues. Request to be set on docket call.
All right, there being no contested pretrials, the court sets this matter for docket call May 1st at 1:30. Go ahead, Mr. Mayor. Who's next?
Next ready on Mr. Jones.
Dennis Ray Jones, CR 24-167 and CR 24-274.
Judge, if we can just, on 274, we are here on pretrial. We have no contested pretrial at this time. Request to be set both on the docket call setting for his next sitting.
All right, court finding there are no pretrial issues. The court sets each case for docket call May 1st at 1:30. Who'd you like next?
Judge, is Mr. Parks on yet?
No, I don't have anyone in the waiting room.
Okay. Then if we can do Mr. Yarbrough.
Audie Bailey Yarbrough, CR 23-195. What's your vote? Go ahead, Mr. Mayor.
Judge, we have not reached a resolution on this case. At this point in time, we request to be set for the next contested docket.
All right, court will set this for a final hearing on the contested docket April 29th at 1:30.
Judge, at this point, I think all I have left are plea on Mr. Robinson and Mr. Jackson.
What about Christopher Slew?
Yeah.
Be there? Got arraignment. We bench warranted him from TDC.
I'm sorry, Judge, I did not have him on my docket. Oh, and also, Judge, I did have Mark Hardy.
No.
Did not have Mark Hardy. Okay.
Will you check on Mr. Hartman?
Judge, sorry, with the confusion from Tuesday, I had a Mark Hardy for a possible plea. That was gonna be a pre-indictment plea. I don't know if paperwork, we were able to get that ready.
You asking me or you asking the prosecutors?
I was just told that the state had said that we weren't moving forward on that, so I was just trying to get clarification.
And I can give you a call in a moment, Mr. Manning.
Okay.
Ms. Tabraham, do you want to reach out to Hunt County?
Yes, your sir. Yes, your honor. Sir.
Spit it out, woman. Spit it out.
Judge, Mr. Jackson, I do have a brief announcement. So
Let me put you on the record. This is
Okay.
call number CR 21-361, State of Texas versus Jaquavion Antron Jackson. Go ahead, Mr. Mayor.
Judge, I reached out via email to try to track down Mr. Jackson's whereabouts, see if he was stuck in traffic or something along those lines. And I received an email just a little bit ago from an unknown email address and phone number So if I may just have a moment over break to see if I can locate the whereabouts of Mr. Jackson. And hopefully we can get him done today as well.
Yes, sir. And so that leaves you Teddy Robinson, you working on big papers, I'm assuming on that one.
Yes, and then Mr. Slough, for an arraignment. I guess, Judge, if we want to, since I wasn't aware he was set today, if we can have a copy of the indictment, I can go over that with him in court.
Sure.
Judge,
Yes, sir.
we are ready to move forward with the arraignment. My client's name is spelled correctly. He understands the charge against him. Pleads not guilty and requests to be set on the pretrial docket.
All right, court finding that Mr. Slew, is that how he pronounces it? Slew or Slough?
Wow.
Slough. Court finding that Mr. Slough has waived the formal requirements of arraignment, enters his plea of not guilty into the record and sets this matter for pretrial hearing on May 1st at 1:30.
And Judge, what was, because it's not on my docket, what was the cause number on that?
CR 24-149. CR 24-001.
Okay, Judge, if I may have a brief break to go over the paperwork
Yes, sir.
with my client and then also track down Mr. Jackson.
Yes, sir.
Thank you.
All right, we'll stand in recess for a brief moment. Mr. Abraham.
Yes, Your Honor.
I have Hunt County available now.
Okay. I think Mr. Manning's on the phone with Mr. Hartwell, so it'll be just a second.
Okay, just let him know.
He's done.
Okay.
We have Hunt County.
All right, this is cause number CR 22-192, State of Texas versus Joseph Leon Parks. Mr. Parks, can you see and hear us okay?
Yes, sir.
Excellent. All right, and you can see your attorney, Mr. Manning?
Yes, sir.
All right. All right, Mr. Manning, I think we were set for status today on Mr. Parks and authorized use of a vehicle charge here. Go ahead.
Yes, Judge, at this point in time, I've not had an opportunity to conduct a meeting with my client in order to discuss potential options or hey guys, hold it up just a little bit. Potential options or resolutions or defenses on this case. And as such, I'd ask for an additional setting. Once I get Mr. Parks benched over here so we can have a cogent conversation about what his options are at this point.
Any objection from state?
No objection, Your Honor.
All right, court will set Mr. Parks then for, I guess we need to set for pretrial. Is that correct, Mr. Manning?
That's correct, Judge.
We'll set this for pretrial on May 1st. And we will execute a bench warrant to have Mr. Parks brought over here. Mr. Parks,
Your Honor, I'm sorry to interrupt. I show that this is actually on an MTR. Motion to
MTR.
revoke.
All right, thank you.
Your Honor, can I ask a question?
Yeah, hang on just a second. I was gonna ask you a question, Mr. Parks. Are you being held in Hunt County on any other charges? I know you have this charge. Do you have an open Hunt County charge?
Yes, sir.
Do you have any TDC holds or?
No, but I'm most likely gonna be signing for time here. And that was my question. I was wondering, do they have an offer over there? I mean,
I'll let you, I'll let you get with Mr. Manning. He will get with you. That's part of what he's asked for today is have time to get you brought over to our jail so he can sit down with you face to face, go over your case, talk about offers and those things, okay?
right.
Judge, and I would just say, I was informed while Mr. Parks was speaking to the court that Ms. Abraham has previously tried to bench warrant Mr. Parks over, and that bench warrant was refused.
Do you know when your next court date in Hunt County is, Mr. Parks?
April 10th, I do believe, but that's for pretrial, and I'm probably gonna be signing for something before then. What I think. So, and I would love to come over there and take care of whatever is there before I even go to TDC, if that's possible.
All right, well, you'll have to let Mr. Manning and the state and this court work that out on logistics. So I think we have tried to bench warrant you, but the sheriff's office over there has declined our order. So we've tried to have you brought over, but we've been declined. So we'll try again. I'll send another order over and we'll see if we can, because we just want to get you brought over long enough to where the attorneys can meet with you, and then we can send you back to Hunt County. We can send you back and forth so that you can get both your businesses taken care of in each place. But we have tried that, not been successful. But we'll try again. But we'll probably, Mr. Manning, you'll need to maybe consult with Mr. Parks' attorney in Hunt County. Who is that, Mr. Parks? Who's your lawyer over there?
Miss Brady, Cynthia Brady.
Cynthia Branning.
Brady, Braddy.
Okay. And then Mr. Manning, if you would mind maybe reaching out, and if he is going to have a hearing on the 10th, maybe if that is not dispositive, I guess if it is dispositive, we can go ahead and do our bench warrant. And maybe she can help us figure out why we haven't been able to get a bench warranted.
Yes, Judge. I'll reach out to Ms. Rabbit this afternoon once I get back to the office.
Okay. All right, Mr. Parks. So Mr. Manning will contact your attorney over there. One way or the other, we'll see you on May 1st. It'll either be on Zoom if we can't get you bench warranted, or it'll be here in our custody if we do get you bench warranted. Okay.
Thank you.
All right, jail staff. Thank you all for getting this hooked up for us today.
Yes, sir. Have a good day.
You as well.
Thank you.
Judge, I believe the last thing we have, is Mr. Robinson. The paperwork we just completed on break should be in your queue.
Public Wi-Fi, you don't have any success. Service appears very critical. It's not like this. Training, we're just waiting. I'm waiting.
Judge, and I just make sure I did go back and confirm that it said that the papers were sent after I clicked the finish button, so.
I believe Ms. Burns has them and she's having technical difficulties as well.
Oh, okay, okay.
So we're just gonna wait for a few minutes.
Judge, if I may, while we're waiting, if I may just step out and make a quick phone call regarding Mr. Jackson.
Sure, go ahead.
Thank you.
Mr. Robertson, I don't know how much longer he's gonna be. You're welcome to have a seat. You can have a seat and then I'll call you back.
Judge, is Ms. Burns able to get that?
Yes, I have it. I'm ready.
Okay.
All right, and before we get on the record, let me just make sure. So I was looking through the plea papers. I see the allegation is theft. It's for deferred. No restitution owed.
No, Judge, the property was recovered.
Okay, that was my question. All right. This is cause number CR 24-285, State of Texas versus Teddy Maurice Robinson. Mr. Robinson, sir, if you'll raise your right hand. Do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
All right, you can lower your hand. Mr. Robinson, are you a United States citizen who reads, writes, and speaks English? And have you ever been diagnosed with any type of mental condition?
That's true.
Okay.
I take medicine,
What kind of medicine do you take?
Xanax, Prozac, whatever they prescribe me.
What is that for? What kind of diagnosis or illness?
I would think for nerves and stuff.
Judge, if I may, in my previous representation of Mr. Robinson, he had competency issues. And so he received help through the Andrews Center and other mental health organizations. And so he is currently on his medication, and he is the best that I've seen him in my representation of him. He understands what's going on. He's asked very important questions. He's very concerned about making sure the court gets paid on time and properly. And so I believe that he is competent at this point in time. He understands what's going on, and he's able to contribute to his defense.
All right, thank you, Mr. Manning. Mr. Robinson, are you pleased with Mr. Manning as your attorney and the work he's done?
Yes, sir.
And do you understand everything that you've read and signed today in your plea
I believe
agreement?
so.
Okay, do you have any questions for Mr. Manning or anyone else?
No, sir.
Okay, all right, Mr. Robinson, you are charged with a third-degree felony offense of theft of property greater than $30,000, less than $150,000. That does carry a range of punishment of not less than 2 years or more than 10 years confinement in prison should you be convicted and sentenced. I see the plea agreement in your case is that the state is asking the court to review the evidence, find that there is enough evidence to convict you, but they're asking the court not to convict you, but to place you on deferred community supervision for a period of 8 years. With you being placed on a mental health caseload, they're agreeing to abandon the enhancement paragraph in the indictment. And they're also asking the court to assess court costs, reimbursement fees, court cost of $290 and reimbursement fees of $520. And there would be no fine assessed as part of this agreement. Is that what you understand the agreement to be and what you're asking the court to approve?
And Judge, one additional condition is that he is going to be submitting to the mental health caseload to be treated under them. I think the important thing that I've seen in Mr. Robinson's life is that when he's on his medication, he's able to stay out of trouble. But it's when he gets off his medication or he lets that medication lapse is when he has problems. And so part of his conditions are to continue with his treatment and medication through the probation conditions. And I've explained that to him as well.
All right, so Mr. Robinson, understanding the charge against you, understanding the plea agreement, how do you plead to theft of property greater than $30,000, less than $150,000?
Guilty.
Are you pleading guilty to that crime because you are guilty of committing that crime?
Yes, sir.
All right, and Mr. Robinson, has anybody threatened you, forced you, or pressured you today to plead guilty?
No, sir.
All right, the court does accept the defendant's plea of guilt. Mr. Manning, any objection to the evidence supporting the plea?
No objection as offered.
All right, stipulation is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
Your Honor, only that victim services is in compliance and specifically reached out about restitution and there was 0 requested.
And they're supportive of this plea? Of
Yes,
this
sir.
probation? All right, anything further from the defense?
Rest and close, Judge.
All right, court will review the evidence. All right, the court, having considered the evidence, finds enough evidence to convict the defendant of the offense. The court will follow the plea agreement today. The court defers a finding of guilt on the 3rd-degree felony offense of theft of property greater than $30,000, less than $150,000. Court places Mr. Robinson on 8 years community supervision, orders him to participate on the mental health caseload, and the court assesses court costs of $290, reimbursement fees of $520. Mr. Robinson, you're hereby remanded to the custody of the probation department so they can carry out the terms and conditions of your probation. Also, I'm going to ask that you step over to be fingerprinted, and then the probation officers will tell you about what's next. Manning, do you have anyone else?
Judge, I believe that concludes my business today. May I be excused?
Yes, sir. And so Ms. Saunders was the only one that you had to be contested here this afternoon, correct?
That's correct, Judge.
Okay. All right. Thank you, sir. Appreciate your work.
Thank you, Judge.
Oh, I'm sorry, Mr. Manning, Mr. Jackson.
Judge, I was unable to get a hold of Mr. Jackson through the contact information that I had. So I have no further announcement at this time.
Okay. I'll see if I can send out a search for you.
I'm sure you guys you'll have him back here soon.
Soon enough. All right. Sir. That's fine. Okay, we'll call all their names. Do me a favor and We're back on record in cause number CR 15-152, State of Texas versus Maria Edith Alicio. I believe that the defense was cross-examining the state's witness at the time that we broke, and I believe that there were some documents that were requested by the defense of this witness.
Yes, there were, Your Honor, during the break. Mr. Crawford provided those documents to the state provided those documents to me. And at this time, I am going to pass the witness.
Okay. Charlotte.
Thank you, Your Honor. And just extremely brief, Officer Crawford, you testified for those UAs that you couldn't exactly remember how you requested that those be done. After having the chance to review your chronos, do you recall on the January 30th date how you requested that be done, or how that conversation took place?
Yes, it was in person. It was a verbal request.
And March 13th?
Same verbal request in person.
Thank you. No further questions, Your Honor. Thank you.
Mr. White, any further questions? No. All right, thank you, Mr. Crawford. You can step down.
Thank you.
State have any additional witnesses or evidence?
Nothing further, Your Honor. State rests in close.
Any exhibits, evidence, or witnesses for the defense?
No, sir. We don't have to confirm. I just asked the court. I don't know when, just to make sure that but we will take up my motion to quash, so I have it on the record.
Yeah, let's go ahead and do that at this time. Go ahead.
Okay, Your Honor, I filed a motion to quash, and in that I alleged that in Roman numeral number 2, that the motion to adjudicate, which also is counts 2 and 3 on the state's motion to adjudicate, alleges that she violated condition B. And condition B.
Let me ask, Mr. White, are you reading the state's amended motion to adjudicate?
Your Honor, state did sign an amended motion to adjudicate. However, state did not, was not able to get that to Mr. White within the 10 days. So state's been proceeding on the original, and I apologize, Your Honor, for not clarifying that earlier.
Okay. All right, sorry, Mr. White, go ahead.
I should say I only received one motion to adjudicate. And it was counts 2 and 3. State alleged that she violated condition B and that she didn't submit a urinary analysis. That is not what's required by condition B. And because of that, that didn't inform us of what she was going to be required to defend. It's required by due process under the United States and the Texas Constitution. And I think that those two ought to be quashed, as they don't comport and don't fairly and accurately put Ms. Malicio on notice, because there is a variance there between the condition of which she was alleged to have violated and then the body of the allegation, which doesn't have anything to do with the condition that she was alleged to have violated. In Roman numeral number 3, we alleged that the motion to adjudicate is not specific in its allegations, and that it fails to inform Ms. Malicio the name and location of any other department that she allegedly failed to report to. Further, because of that, the alleged violation is so broad that we couldn't prepare a defense, because any other department could mean any department within the state of Texas. It wasn't specific as to wasn't specific as to which department that she failed to report to. Now, while I will concede that the state does not have to plead these things with the amount of specificity required on the, that would be required on an information or an indictment, there is still a specificity requirement, and I do not feel that it was met on this because they're the ones who chose to add in or any other department. And it's impossible to determine which department we were talking about. And Roman numeral number 4 states that in count 5 that Ms. Malicio was alleged to have left the state of Texas without written consent of the court. And again, that didn't provide us with enough information to prepare a defense, as it didn't allege a time frame at all as to when she allegedly left the state, nor did it allege where she was. And, you know, I would say that on its very face, I mean, that, you know, however this is, you know, when we get down to the specificity requirement in terms of a jeopardy argument, it's got to be enough to keep them from being able to refile. And if they can allege that she left the state and don't even allege a date and don't allege where, then, you know, theoretically, you know, you could always come back and say, well, no, we weren't talking about that particular date or that particular time. And so in order to be able to properly defend her, we needed to know what that was. And the state didn't allege that within the motion. And so we're going to ask that the court quash counts 2, 3, 4, and 5 for those reasons stated.
Response?
Thank you, Your Honor. Your Honor, as to counts 2 and 3, as the testimony showed, Ms. Malicio was on notice from her meetings with Ms. Officer Crawford that failing to submit to a UA would be considered the same as a failed UA. Because she was on notice that failing to submit would be considered a violation of condition B, just as well as it could be a violation of condition L. She was on notice that that failure to submit would be considered a failure of really either condition. Further, it's specific as to what's alleged and the date of the violation. Those are specifically laid out in the motion. If really, it's a matter for the court to make a determination if the evidence presented through testimony rises to the level to prove the allegation true or not true by a preponderance of the evidence. I think quashing the allegation entirely is inappropriate, as it is specific as to what condition is alleged to have been violated, when it is alleged to have been violated, and how it's alleged to have been violated. I believe that the testimony does show and is adequate to show that Ms. Malicio did violate it. However, that would be a matter for the court to make its determination on in weighing the evidence. So I think for counts 2 and 3, quashing would be inappropriate. As for count 4, Your Honor, given similarly, we have a date, the month of December 2017. So we know when we're talking about, and we do know what we're talking about. We're talking about condition D, which, reading it, report to the probation officer at the Community Supervision and Corrections Department as directed by the court and your probation officer at least once each calendar month, beginning immediately and continuing until you are discharged from probation, and obey all rules and conditions of the department. In this case, the testimony of Officer Crawford was that she was instructed to report to the Van Zandt County Community Supervisions Department, and that she failed to do so. That is laid out in the motion, and I think that it is clear that, especially given frequency that probationers report outside, whether their probation is transferred to another county within the state or transferred to another state. That is what that language is intended to communicate in the motion. In this case, Ms. Malicio was supposed to be reporting to Van Zandt County and she failed to do so. Again, with the specificity of having the date, the condition that she's alleged to have violated and how she violated, state believes that the allegation is clear. And again, it's a matter of the weight of the evidence for the court to determine. Count 5 of the motion to adjudicate, Your Honor. Condition G requires that a probationer remain within the state of Texas unless you have first secured the written consent of the court to leave therefrom. Here, really, the date range is going to be from the start of probation to the end. It's can be a large date range. However, if somebody leaves, probation department may not be made aware of it for more than a month. So trying to nail down a specific date that the defendant did leave can be difficult. However, if we look at the motion in its entirety, count 1, Your Honor, alleges that she committed an offense in Tennessee on a specific date. So looking at clearing up ambiguity, that would be a fair place to start. And there is a specific starting point within the motion. And so again, I think it would come down to the weight of the testimony given from the witness stand. Your Honor, state asked the court to deny the motion to quash in its entirety.
Final word on that, Mr. White.
Your Honor, I mean, we're not arguing right now the merits of, my understanding, the merits of what the evidence. We're arguing about notice and what's required under due process as far as making a defendant able to present a defense. And when you allege that condition B has been violated, and then that'd be no different than saying, in an indictment or an information that somebody, okay, they violated the crime, and then they start trying to make it into something else that isn't that, and it creates a problem because she's alleged to have violated condition B, and there is nothing within the state's allegation that applies to condition B. In fact, it just doesn't give you enough. It doesn't. There's a variance there. It's not the same thing. And when we get down to where we're talking about leaving the state and those sort of things, well, first off, it could have been a different violation. I would say that, count 1, if we're going to talk about what was it, there's no evidence that there's been any violation because there's no evidence of count 1. But however you cut it, just because the state makes an allegation doesn't make it so. And that seems to be what the state is arguing here. Oh, well, we said it, so therefore it's true. And, that's not, in my view, it doesn't work that way. They've got to allege what has happened. And in order for her to prepare a defense, hey, look, you left the state, need to know approximately when and exactly, or approximately where, at least. It doesn't even have that. It just says you left the state, doesn't even say when. For all we know, it wasn't even, it could have been previous to her amended probation conditions. We don't know. The court has no way of knowing that particular allegation is within, the current, that didn't involve any of the other alleged violations that occurred before in previous motions. And so that fails totally. And the court should quash, in my view, counts 2, 3, and 4.
All right, court, having considered the argument of counsel, the court hereby denies the defendant's a motion to quash as to counts 2, 3, and 4.
And 5 as well, Your Honor.
5 as well. All right, Mr. Earl, would you like argument on the motion? For a vote, motion to adjudicate?
Your Honor, state would rest on the record.
All right, Mr. White.
Very quickly, Your Honor, I would point out, without going through my arguments, are going to be basically the same, so I'm not going to reiterate. In the count condition B, they did not prove that the state did not prove that she violated condition B. If they proved anything up, they proved up that she may have violated condition L, but she wasn't alleged to have violated that. As far as count 4 goes, there was no evidence presented that the state made an in-home visit at her last known address to determine that is required under due diligence. And state simply did not meet their burden on that because they didn't present any evidence at all that the state attempted to make an in-person visitation once she had allegedly, absconded. As to counts 1 and 5, I think they're the same in that the state presented no evidence whatsoever on those because the court overruled it that she left the state. It was all based upon this alleged crime in count 1. There was no testimony as to that from any competent witness, and the state's not met its burden on those. And then we get down to counts 6 and count 7. Now, if the court finds that she did not violate those, first note the state did not prove any evidence that she had the ability to pay and didn't. But even if there was evidence or whatever that she did, there was no showing that the previous court presiding judge conducted any review to make a determination as to whether or not she could actually pay those things. And she's been alleged to have violated, her probation by not paying her attorney's fees, which indicates that she was indigent. And there needed to be that made. So we've got a situation where, I believe that these operate as somewhat of a negation type situation, and the state presented no evidence on that. No evidence saying, yes, the court made this determination prior. And as I said, there's also no evidence that she could pay and did, depending on which route the court goes down. And, just because we allege these things and then we put the probation officer up there to testify, we still don't have a lot or really any testimony that indicates when some of these violations, like 2 or count 5, for example, when that even occurred. And of course, count 1, there was no testimony from an officer or anybody on that. And when you get down to, when we look at 2 and 3, again, and I know I don't want me to sound like a broken record, but that they said she violated a condition by not submitting to your analysis. And that condition does not require that. And I don't believe the state has met the burden of proof on any of the counts, and would ask the court to find and release Ms. Felicio.
Thank you, Mr. White. Ms. Harwell, anything in rebuttal?
Your Honor, I adopt my same argument from the motion to quash regarding most of these counts. As to count 6 and 7, Your Honor, there is a presumption that proper procedure is followed by courts when entering judgments. There is a presumption that judgments are valid. Furthermore, Your Honor, when looking at the conditions of probation in State's Exhibit 3, Ms. Malicio was ordered to pay $50 a month. When in the amendment to the conditions of probation, which were filed March. I'm sorry, Your Honor. Oh, I'm looking at the wrong one. But in, Your Honor, in states, Exhibit 4, in the amended conditions of probation, again, the court would have been presented with evidence. Ms. Malicio would have had an attorney, and yet the amount to pay was increased to 100 with the presumption that the court followed proper procedure. The court did make a determination that she could afford $100 a month, $50 a month. And as Officer Crawford testified, she never brought up to him that she was having difficulty to pay. So with the presumption that the court followed proper procedure in the beginning and no evidence that she ever informed anybody that she was having difficulty, Your Honor, state believes that this was that it has proven that this was a failure and not an inability. State would ask the court to find that Ms. Malicio did violate the conditions of her probation, revoke her probation, and continue to sentence him today.
Thank you, sir. All right, then, the court having considered the evidence and arguments of counsel, the court also having considered the exhibits and the evidence admitted herein with regards to state's motion to adjudicate and revoke community supervision file May 8th, 2000 and what appears to be 18. State has alleged in 13 separate counts, allegations that Ms. Malicio has violated the terms and conditions of her community supervision, which flowed from an August 27th, 2015 plea agreement in which the court found that there was substantial evidence to convict the defendant and to, or substantial evidence to convict the defendant and establish guilt for the third-degree felony offense of possession of a controlled substance in penalty group 1 greater than 1 gram but less than 4 grams. That on that date, the court followed a plea agreement and deferred a finding of guilt and placed the defendant on a period of community supervision for 6 years, and that the court also assessed a $2,000 fine. And then on that date, the court ordered the defendant to abide by certain terms and conditions of said supervision. As to count 1, the court finds that the state has failed to present any admissible evidence with regards to the allegation contained therein. Therefore, the court finds count 1 not true. With regards to count 2 and count 3, the court finds that the state has alleged a violation of condition B of her community supervision and her failure to submit to a urinary analysis. The court finds that the state has failed to present any evidence that she has violated condition B, which does not require a urinary analysis. Therefore, the court finds count 2 and count 3 not true. With regards to count 4, the state has alleged that the defendant has violated condition B of her community supervision, which she was ordered to report to the probation officer at the Community Supervision and Corrections Department as directed by the court and probation officer at least once each calendar month, beginning immediately and continuing until she was discharged from probation, and therefore to obey all rules and conditions of the department. The court finds that the state has proven beyond a preponderance of the evidence that the defendant failed to report to the Community Supervision and Corrections Department for the month of 2017. The court finds count 4 to be true. With regards to count 5, court finds that the state has failed to present any admissible evidence to prove the allegation contained therein. The court finds count 5 not true. With regards to counts 6, 7, the court finds that although evidence has been produced by the state regarding Ms. Malicio's failure to pay a financial obligation, the court finds no evidence that Ms. Malicio had an ability to pay and did not pay. So the court finds count 6 and count 7 not true. The court finds with regard to count 8 that the state produced no evidence whatsoever regarding the allegation that Ms. Malicio failed to pay or attempt to pay restitution as ordered for the months contained therein. Therefore, the court must find count 8 not true. With regards to count 9, the court finds that the state has failed to present any evidence whatsoever of the defendant's failure to pay urinary analysis for the months contained therein. Therefore, the court must find count 9 not true. With regards to count 10, the court finds that the state has failed to offer any evidence whatsoever of the defendant's failure to complete a minimum of 10 hours community supervision restitution as ordered by the court. Therefore, the court must find count 10 to be not true. With regard to count 11, the court finds that the state has offered no evidence to prove the allegation that the defendant failed to attend sanctions court for the month of March 2018. Therefore, the court must find count 11 to be not true. With regard to count 12, the court finds that the state has failed to offer any evidence whatsoever that the defendant failed to successfully complete a drug education program within 90 days. Therefore, the court must find condition 12 not true. With regard to condition 13, the court finds that the state has failed to produce any evidence whatsoever that the defendant violated the terms of her conditions of community supervision by failing to submit to an alcohol drug evaluation within 90 days. Therefore, the court finds that condition 13 is not true. All right, the state and defense is entitled to a separate hearing on punishments should the court find that the defendant has violated any terms and conditions of supervision. At this time, court having found count 4 to be true, or would revoke the defendant's, the court would adjudicate the defendant's guilt and revoke her community supervision. At this time, each party is entitled to a separate hearing on punishment.
Yes,
All
sir.
right, right.
We'd ask the court to hold this in order of PSI and reset it for hearing. Okay.
State.
Your Honor, state would have no objection to a PSI. I believe it's discretionary after a motion to adjudicate.
Anything else? I thought you were just arguing.
No, Your Honor, I believe it's discretionary after a motion to adjudicate. And state would have no opposition to a PSI and taking up punishment phase at a later date.
Okay. All right, the court will grant the defendant's request for a pre-sentence investigation report to be completed. And the court will set this matter for sentencing on Tuesday, April 29th. At 1:30. For the This time is finding Ms. Melissio's bail in this case to be insufficient. And will order her to be taken into custody.
Your Honor. I would ask the court to reconsider that and ask if, Ms. Malicio submits to a drug test and she tests negative, the court retain her on bail so that we can more easily prepare our defense for punishment.
I understand the request, but it's denied at this time. No, man, don't raise your hand. If you have something to say, talk with your attorney. That's in your best interest.
Your Honor, may we have a moment before she gets transported so she
Call my kids, please.
call people.
She'll have to do so in the courtroom though, because she's in the court's custody at this time, but we will not detain her further to allow her to do so. But she's got to remain, you got to remain in the courtroom. All right, I believe that concludes court's criminal docket for the day. Court is adjourned. I'm sorry. Before the court adjourns, the court has had the names Jaquavian Jackson, Paul Lowley distinctly 3 times. Mr. Jackson's order to appear at the Vanderbilt County Justice Center to enter into a plea agreement today. He's failed to appear. His name has been called both at the Vanderbilt County Justice Center and here at the Vanderbilt County Courthouse. Mr. Jackson has failed to appear in the court here by issues of judgment nisi alias capus. The court has also called
I'm sorry.
oh, yes. Court is also in Constantine CR 25-25. The name Clayton James Spencer. Mr. Spencer is here this morning. Pretrial. Failed to appear. Paul Lally distinctly 3 times in the courthouse with no response. Court hereby issues a judgment not signed. Alias capus.
I'm sorry, sir, but yeah, okay.
All right. Court is adjourned.
There were a lot of phone calls going on.
Oh, so here.
I didn't know you already had.
Have I done?
No.
She,
Yes. Have a good weekend.
It's fine.